Is it connected or what?
Yes. There are two cases. One case I got bail. They are for cancellation of bail. The other case, my bail was rejected. That's why I. The first case is their cancellation.
So they are two different cases.
Two different
They are
cases.
two different cases. Uh, Lordship, in item number 1, I am the appellant. And I'm agreed by the order dated 18/6/2025, which your Lordship will find on page 17. And primarily, the bail was granted on the premise that the father, or the relatives of the accused, they were not informed about the grounds of arrest. And your Lordship will find, if I may take your Lordship to page 29, the operative portion. The order.
29.
Page 29 of the memo of appeal is a part of the, is the internal page 13 of the interim order.
Yes.
As such scrutiny, the undisputed fact that transpires before this court is that the accused was admittedly arrested on 19/5/2025. However, perusal of the record reveals that as against the pleadings of the NIA, that the accused was duly served notice regarding the ground of arrest, and his father, namely so-and-so, was also informed about the grounds of arrest of the accused, he is found to be not worthy of credence, as the case record nowhere reveals that the father of the accused has been informed about the grounds of arrest of the accused in writing as required by section so-and-so BNSS. Record reviews only about compliance of section 47. So the court was of the view that section 48 has not been complied with. The court has also taken into account the judgment rendered in Vihan Kumar, and that it has to be in writing. Now, so far as Lordship informing the relatives of the accused is concerned, Lordship, if I may take your Lordship to page 12 of my memo of appeal, ground I. Ground I.
Page 12.
Page 12 of my memo of appeal. Ground I. I state that on 19/5/2025, after the arrest of the accused person, an intimation that is copy of arrest memo and ground of arrest was sent through email from NIA control room Imphal to email SP so-and-so district Manipur, that is so-and-so, for serving to the family members of the above accused persons. As per record, the intimation regarding grounds of arrest has been received by the brother of the accused on 25. He was arrested on 19/5. Brother of the accused came to know on 25, and the same has acknowledged the receipt of information regarding the arrest of grounds of arrest on 25. Now, what has happened here is, Lordship, there was some delay in transmission of this information from the state police to the NIA. The CIO received a copy of the acknowledgement through
What
WhatsApp.
is CIO?
Chief Investigating Officer, Lordship. The CIO has received a copy of the acknowledgement through WhatsApp on 10/6/2025, and the entry of the same is made in the CD, and later on original acknowledgement was received by the CIO from the SP officer. There was, Lordship, some, Lordship, time was consumed in receiving the original, although it was informed that the grounds of arrest was received by the brother On 25, the acknowledgement through WhatsApp was received by the NIA on 10/6, and thereafter it was entered in the case diary on receipt of the original acknowledgement. So, Lordship, it is not a fact that the relatives of the accused person did not know about it. And insofar as, Lordship, the case of Rihan Kumar is concerned, Lordship, Rihan Kumar has now, Lordship, a latest decision of the Supreme Court has come few last months. The delay in informing. This is a case, I'll give a copy, Lordship. State of Karnataka versus Sri Darshan. And the decision came on 14th of August this year. This is a downloaded copy of the Supreme Court order.
Copy.
I have a I have a SCC online copy. I'm just that is another one. There is another. If your Lordship will come to paragraph 20.1. Uh,
21.
20.1.
Yes.
Delay in furnishing the grounds of arrest cannot by itself constitute a valid ground for grant of bail. The learned counsel for the respondent accused contended that the arrest was illegal on the grounds of arrest were not furnished immediately in writing, thereby violating Article 22(1) of the Constitution and Section so and so of the Bharatiya Nagrik so and so. This submission, however, is devoid of merit. Article 22(1) of the Constitution mandates that no person who is arrested shall be detained in custody without being informed as soon as may be on the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Similarly, Section 51 of CRPC requires that every police officer or other persons arresting any person without warrant shall forthwith communicate to him the full particulars of the offense for which he is arrested or other grounds of such arrest. The constitutional and the statutory framework thus mandates that the accused person must be informed of the grounds of arrest, but neither provision prescribes a specific form or insists upon written communication in every case. Judicial precedents have clarified that substantial compliance of these requirements is sufficient unless a demonstrable prejudice is shown. Now, here is a case where the accused himself has to be informed. And insofar as the parents are to be informed, my submission would be logical. In any case, the accused has been informed. The parents have also been informed. The only difficulty that was there before the court was that the original acknowledgement we have received it a bit late from the state police.
Let us take the provisions of the.
Forty-seven and 48. But the Supreme Court says, Lordship, if no prejudice is caused, then that will not have any bearing. Now, in this matter, Lordship, he was already being represented by a counsel. 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 No.
Yes.
Now, Lordship, though the accused person had the knowledge, the only issue before on which the court had granted him bail was that there was no material to show that information in writing was given to the family members. This paragraph makes it very clear at page 29. However, perusal of the record reveals that as against the pleadings of the NIA, the accused was duly served notice regarding the grounds of arrest and his father, namely so and so, was also informed about the grounds of arrest of the accused is found to be not worthy of credence, as the case records nowhere reveals that the father of the accused has been informed about the grounds of arrest. At page 29, that is internal page 13 of that impugned judgment, Lordship.
30.
1-3. 1-3. On such scrutiny, it starts. Yes. Middle portion, Lordship. Is not worthy of credence, as the case record nowhere reveals that the father of the accused has been informed about the grounds of arrest of the accused in writing as required by section 48 BMSS. So this is the only ground on which the court has granted him bail. It further goes on to the learned court says, therefore, it is seen that even though there is compliance of section 47 of the BNSS, there is non-compliance of section 48 of BNSS, which is writ large on the face of the record. Now, whether this has caused any prejudice to the accused, Lordship.
Vihan Kumar,
Vihan,
this Vihan Kumar, what about the after the judgment that has been occurred by justice protector?
yes, it is there, Lordship. But then again, there is a clarification in the latest decision of the Supreme Court, Lordship.
So now, what is the law? What is the law when there are two judgments of the Supreme Court?
No, in our case, it is not a case where we have not communicated. We have communicated.
No. What basically you have communicated late. According
No.
to you, you have communicated late to the family.
No,
One day
That-
late, according to you. One day late,
it-
19 requested,
19th,
communicated on 20th.
20th. It was
Day late.
Lordship.
Whether it is a delay fatal or not, that's a different issue, but there is a delay,
Lordship.
rightly or wrong. Now, the fact that the communication was made and recorded in the official record after 20 days, 21 days in fact, is also not disputed. Because it was sent to the CIO by WhatsApp on 10th
It was
of the next. So 21 days. Now, leaving aside whether the delay is fatal or not, leaving that aside,
Lordship.
not, it cannot be left aside actually. The issue is basically whether the delay is fatal or not. Now, for grounds of arrest, that has to be communicated immediately to the person who is arrested,
Lordship.
correct?
Lordship.
As per the law. Now, the issue is whether it will be fatal if that is not given to the relatives or the family of the arrested person. Now, Justice Koteshwar in the judgment,
Lordship.
I think at page 33,
Yes, Lordship.
hence the second line. What does it say?
It starts from page 31.
I know, but just instead of reading the entire thing, just come to the operative portion. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person,
Lordship.
also to the friends, relatives, or such other person as may be disclosed normally.
Lordship.
So as to make the mandate of Article 22(1) of the Constitution meaningful and effective,
Lordship.
failing which such arrest may be rendered illegal.
Yes. If we may read it once again, Lordship.
Okay.
Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution, so and so. Now, it says that the grounds of arrest has to be communicated in writing. It does not say I have to do it at the same time when the person is arrested. Now, naturally, after the person is arrested, only after that, the information as regards the son of whom or whether he is and all those things will come up. So, it does not say that I have to give it to him at the,
Simultaneously.
at the same moment. Grounds of arrest we have coming. Forthwith does not say just now. Now, we have communicated. That is our stand. We have communicated and his brother has received it on the very next day. Therefore, there cannot be any prejudice. And had it been on some other ground, Lordship, yes, he might have had a case. Now, here is a case where the accused person has come before the court represented through a lawyer, and that is much later. Now, where is the prejudice caused? There is no prejudice, Lordship.
Okay, so your submission is Supposing a person is arrested on the first day, say on day one, and the communication to his family is made after 7 days.
That may be fatal. Here is a case,
So according to you, 1 day delay not fatal.
one day, in the instant case, I would say it is not fatal because when he has preferred the bail application, by that time, he knows everything because this bail application was preferred much later. Much later.
So you
So that cannot be a ground to grant him bail that the parents did not know. Parents did know. They have complete.
okay, anyway, so your case is that 1 day delay is not fatal. Basically, that's it.
Basically, and now, Lordship, considering a bail application, Lordship, the law laid down by the whole Lordship Katina of judgments is, Lordship, what's the gravity of the offense? At least that has to be also kept in mind. Now, a mere technicality of a single day pitted against the gravity of the offense. Lordship, that has also to be considered.
When you talk of gravity of the offense, it depends on various factors.
Yes, Lordship.
In some cases, like POCSO is 20 years or 10 years, NDPS is 10 years, 20 years. These type of cases may be life sentence. Conversion of religion life.
It would
It is
depend,
very
but
subjective.
it would depend on the facts of
Cannot-
each case. It would depend on the facts of each case, Lordship. That is,
So you cannot say, you cannot put a certain,
it cannot be in a straitjacket formula, Lordship. I do agree, it cannot be in a straitjacket formula, but what has happened here is, Lordship, Lordship knows the Manipur crisis. Now, here, two, 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 two security personnel were killed, others were, Lordship, injured, and whole lot of, Lordship, public were also injured. Now, under such circumstances, with this small technicality would play in the mind of the Honorable Court.
what do you think of a case where number of drugs are seen? Drugs, they are killing thousands of persons and causing problems to thousands of families. The law has to apply to them all.
Yes,
Well,
yes, yes.
so you cannot put anything in the straight jacket out here.
No,
If 2 lives are killed,
I agree with
the
your
drug,
lordship on that.
maybe 1,000 lives are killed.
I agree with your lordship on that.
So we have to follow the law. Whether your interpretation will be correct or not, we'll see. Basically, what you're trying to say is 1 day delay is not fatal and no prejudice is possible. And this judgment of Vihan Kumar cannot be applied in the fact of listed, with the fact of
Lordship.
That's all. That's
And the delay and the intimation in communication, intimation in writing, that we have done. That we have done, but that's a delay of 1 day.
where do you prove that you have
That the
communicated?
that records will very records and form.
They have not annexed.
I have not, but I can produce the case records, Lordship.
See,
Lordship, Lordship, that.
that is one aspect, that's the factual aspect you have to see. We do not know.
Lordship, in some time, Lordship, it will come. It's, I'm asking them to debate.
Anything else?
Lordship, primarily that subject to what my friend says.
Well, in this case.
Hmm?
What?
And there is one thing I forgot to point out, Lordship. He was, although he's from a distant place in Manipur, that's near that international border, but he was arrested from near Assam, Silchar. And this unrest was near More.
And then,
Near More. The incident occurred near More.
so people can travel.
Now that's
Doesn't mean that just because someone lives somewhere, he has to remain all his life there.
Lordship.
In the last 1 month, where have you traveled? Outside the Assam, you must have gone. I have gone number of times. You have gone. Everyone goes somewhere here. Not say that just because someone says.
Lordship. Lordship, lordship.
Lordship may have a look at page 42 of the petition.
Is your documents coming today?
Uh, They are ringing. Oh, lordship. It will take another around 1 hour, lordship. Go.
I don't know. It depends upon your. Yeah.
Or if your lordship, I subject to what lordship says, I can, if it comes, I can keep it in the court, lordship, and lordship can take it up tomorrow with that.
Tomorrow.
Lordship, then let us pass.
Tomorrow I have got to.
Hmm?
go somewhere
Second half.
to attend one. Juvenile justice.
Lordship, it might come also, lordship. This,
Yeah.
My lord, page 42, my lord. The paragraph 14, my lord. From below, my lord, 8th line, my lord. Therefore, my lord, lordship, found that, my lord. Therefore, the arrest of the accused person without complying the provision of Article 22(1) of the Constitution of India, as well as the provision provided under Section 47 and 48 of the BNSS 23, and the relevant provision of the said acts renders the arrest illegal and arbitrary. Therefore, the detention of the accused person is arbitrary, and as such, he may be allowed to go on bail. Next paragraph also, my lord. Paragraph 15, my lord. After this judgment, my lord, your lordship will see, my lord. It has further held that a communication to the relative or to the friend of the arrested person must also be made in writing. However, in the instant case, no such communication has been made to the relative or friends of the arrested accused person as mandated by Section 48 of the BNSS. This plea was taken in the bail application, my lord, and they have filed a reply, my lord. That reply your lordship will find at page 52, my lord. Page 52, paragraph 11 and 12.
Yes.
That the allegation of para 11, 14 are denied. It is again reiterated that all the due procedure of law, procedure as laid down by the law and the honorable court by judicial pronouncement were duly complied at the time of the arrest of the accused. Therefore, it cannot be said that the arrest of the accused is illegal and arbitrary. Next paragraph, my lord. In reply to paragraph 15, it is submitted that the father of the accused, namely so-and-so, was informed about his arrest. The accused himself signed the arrest memo after his arrest, and he was told about the grounds on which he was arrested. Therefore, all the necessary obligation on the part of the investigation agency was duly complied as mentioned in the judgment cited in the para. My lord, this objection was filed by the via, my lord, on 2/6/25, my lord. That is, a lordship will find at page 49. So till, my lord, 2/6/25, they could not produce that document.
There is no brother.
Nothing.
That
Now, my
it
lord,
was not the stand that the brother had been informed.
they, my lord, till 2/6, nothing, my lord. Now, in this appeal, my lord, at paragraph I, my lord, now they have taken this stand, my lord. Page 12, my lord. That on 19/5/25, after the arrest of the accused person, an intimation, that is a copy of the arrest memo and grounds of arrest, was sent through email to the NIA control room, Imphal, to email SP Tanglong district, Manipur, that is so and so, my lord, for serving to the family members relative of the above accused. As per the record, the intimation regarding grounds of arrest has been received by the brother of the accused on 25/25. Well, where is that document, my lord? While filing this, my lord, they feel they could have annexed this document, my lord. That is not on the record, my lord. My lord, the step by step they are developing the case, my lord. And so far, my lord, my learned friend, my lord, which he has relied the case, my lord, of Darshan, my lord, that is with regard to section 47 of the BNSF, my lord. My argument is not on 47, totally on 48. Therefore, my lord, this communication was not made, my lord. They are developing the case, my lord. On two, my lord, we have filed their bail application on 28/5, my lord. Thereafter, they filed their reply on 2/6/25. Till then, nothing was said, my lord. Only denial. We have served and the paragraph is denied, but nothing on record they have shown. So therefore, the order passed by the trial court, my lord, is correct, my lord. That much permission I have. Till now, my lord, that record is not available before. And Vihan Kumar, it is specifically stated, my lord. And 48, my lord, it says, my lord, every police officer or other person making any arrest under this Sanhita shall forthwith. The word forthwith is there.
Maybe 1 or 2 hours delay to 3.
That will be.
2 hours delay here and there.
But till 2/6, Mala, there was nothing. Till date today also, Mala, there is nothing on record to show that they have served the copy.
I will produce the recording now.
We're waiting for it. Waiting.
I'll produce the.
So, since we have heard everything,
Fine.
we'll wait for another hour or so. Then we'll pass the order.
No, sure.
Correct.
Mala, second case, Mala.
Yes, sir, it is.
Yes.
This is a different matter.
Same person.
Maybe
Fine.
he can be granted in one,
Mala.
denied in the other,
But
convicted in one, acquitted in the other. Okay, right. This has to be possible.
next
Not deputy as there. For the excellent national investigations agency. Bracket United. Also had Mr. N.J. Dalton. The learned counsel for the accused respondent. Accused respondent.
yes.
The present appeal has been filed under section 21/4 of the NIA Act 2000. As the appellant is agreed with the final order dated 18/6/2024. Issued by the learned judge court NIA, Assam, granting bail to the accused respondent in bail petition number 486/2025 in connection with RC 05/2024/NIA GUW. The the respondent appellant had been arrested by the who? Arrested
Can I
by
give
whom?
arrest?
Sequence. Sequence. NI. By the NI. NI.
Was arrested by the NIA in connection with the attack on the IRB post located at Imakdong, IRNB, packet KLP More, Tengnupal district. It is at page 4, no, Karachi, by suspected Kuki militant, which resulted in the death of how many? Any death, which resulted in the death of one security person. The accused respondent was arrested on 19/05/2025 at 3:30 AM in the Silchar police station, Kachar. Next part. Continue. The appellant was, the accused respondent was arrested on charges eight persons. What is the police station case number? In persons to case number RC dash 05 dash 2024 dash NIA dash IN under section 121, 121 A, 302, 307, 325, 353, 400, 30. The accused appellant submitted an application for bail before the special judge, NIA FM Guwahati
On 23/5.
on 23/5/2020. The special judge NIA granted bail to the accused respondent on the ground that section 48 of BNSS had not been complied with. Inasmuch as the case records nowhere reveal the fact that the father of the accused respondent has been informed for the cause of arrest of the accused respondent. Next slide. The Mr. R.K.D. Chaudhary, the deputy SDA. Interesting. That on 19/5/2025, after the arrest of the accused respondent, a copy of the arrest memo and ground of arrest was sent through email from the NIA control room, Imphal, to the email of the SP Tengnupal district, Manipur, page 12, para I, Manipur. That is septengnupa@manipur.gov.in for serving to the family members slash relative of the accused respondent. He submits that as per record, the communication regarding grounds of arrest had been issued by the brother of the accused respondent on 20/05/25 and the same had been acknowledged, and the brother had acknowledged the receipt of the information regarding arrest and the grounds of arrest on 20/05/20. The chief investigating officer had also received a copy of the acknowledgement to WhatsApp on 10/06/2020. And the entry of the same was made in the diary. And later on, the original acknowledgement was received by the chief investigating officer from the SP office from Tengnopal district, Manipur. Next part. The learned deputy SBI started that in view of the fact that the grounds of arrest had been received by the brother of the accused respondent 1 day later, that is on 20/05/2020. The reason for grant of bail by the special NIA court sample to the accused respondent was bad in law and on fact. As such, the bail application should be set aside. The bail granted to the accused respondent should be set aside. As section 43D
Yes.
of the unlawful activities bracket prevention bracket close act of 1957. Here and after referred to as the UAP Act. Is a strict provision. It has to be applied vigorously. That's all. What else? No, sure. In this respect, in support of his submission, the learned deputy SJ has relied upon para 20.1.
The
the judgment-
paragraph 20 in whole, Lordship, the paragraph 20 in whole, I would just, if your Lordship would permit,
Yes, yes.
I would just read out from 20.1.
It becomes too long.
It's a bit,
20 runs
it's, if your Lordship will, if your Lordship,
say, they relies upon.
if your Lordship will kindly see paragraph 20.1.5,
1.5.
1.5.
Yes.
While section 50 CRPC is mandatory, a consistent judicial approach has been to adopt a prejudice-oriented test when examining alleged procedural lapses. The mere absence of written grounds does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of a fair opportunity to. Now, he was already being represented.
No, but then there are judgments just prior to this. I
No.
think not only in Bihan,
No,
but in that
Modulemi,
Raghubir, Purkaista, which says that it has to be in writing. Now, you tell me,
no,
you are relying upon one judgment. He's going to rely on another judgment. Now, which
no,
judgment
I
is
am,
supposed
I
to
am,
follow?
Worship, I am relying upon the latest judgment.
Correct. Now, the thing is, when there are judgments passed by the Supreme Court of equal strength, which is of equal strength, the High Court is supposed to follow which judgment? As per Pranay Sethi's case, by Constitution Bench judgment of the Supreme Court, it has held that the earlier judgment should be followed. If you can give me a better judgment higher than 5 judges bench, then I will follow. I will follow.
Yes.
You see, that is the thing. We have got to follow the law laid down by the.
But in any case, it is not my submission that we have not given the written information. We have given.
Correct. But now the thing is that you are saying that you have given to the father,
No, it may,
in the
no,
NIA.
no, the records will,
Thing to the brother.
no, the records will reveal whether communication to the father has been received by the son. No? The records will reveal, no, whatever is there.
In the arrest.
The records would reveal.
One will be 1 hour. Right. So where are we? You just say para 20. 20.1 of the judgment, 20.1 of the judgment passed by the Supreme Court in the case of State of Karnataka versus Sri Darshan, etc. Criminal Appeal numbers 3528 3534 of 2025. Good job. Wherein the Honorable Supreme Court had held that had negated the contention of the learned counsel for the respondents that the arrest, no, but this is with regard to 47, not with regard to 48. This is with regard to 47. 20.11 is regard to 47, not 20, not 40.
It
Is with
it is only on the ground. I am stressing only on the ground of delay and the written communication. Lordship, yes, the accused has to be communicated in writing and the family members also.
no, it does not talk about family members.
No, this particularly does not say about the family members. What I am on is that the delay.
Wherein it has been held at para 20.1.5 that while section 50 CRPC is mandatory, comma, the consistent judicial approach has been to adopt a prejudice-oriented test when examining the alleged procedural lapse. The Supreme Court has held that the mere absence of written ground does not ipso facto render the arrest illegal, unless it results in demonstrable prejudice or denial of a fair opportunity to defend. Next. On the other hand, the learned counsel for the accused respondent submits that the reading of various Supreme Court judgments prior to Sri Darshan Supra, that is Pankaj Bansal versus Union of India. Pankaj Bansal was here, no, was Union of India. 2024, 7 SEC 576, Prabir Purkaista versus State bracket NCT of Delhi. What is the citation? And
Pankaj Bansal is 2024 7 SCC 576 and
and then
Prabir
Purkaista,
Purkasta is Lordship 2024 8 SCC 254.
8 SEC 254.
254.
And in the case of Rihan Kumar versus State of Haryana. 2025 SCC online. SC 453. Whatever, just read, I've forgotten my train of thought. Come on. Requires the arresting authority to not only furnish the grounds of arrest in writing to the arrestee, but also to the family member of the arrested. This has also been a mandatory requirement under section 47 and 48. BNS. Correct?
Yes, only 48, but related.
Both, both.
It is-
You have understand. Next. Next. The learned counsel for the accused respondent further submits that for the first time, the appellant has taken a stand that the grounds of arrest have been communicated to the brother of the accused respondent. In the proceedings that were held before the special judge in Assam, the stand of the appellant was that the grounds of arrest had been informed to the uh, to, to the father of the accused respondent, and there was no whisper of the brother of the accused respondent being informed of the arrest of the accused. We also submit that till date, the appellant has not been able to produce any document which shows that grounds of arrest had been communicated to either the to either to the father, to the family members of the accused. That's all. Anything else?
Yes.
Right. We have heard the learned counsel of the court. As can be seen from the report, bail has been granted by the learned special court NIA Assam to the accused respondent only on the ground of non-communication of the grounds of arrest in writing to the family members of the accused respondent. And as such, bail was granted by the learned special court in terms of, in view of special court due to violation of section 48 of the BNSS 2022. And in keeping with the decision of the Supreme Court in Vihan Kumar. Correct?
Yes.
That's right. As has been rightly pointed, next para, as has been rightly pointed out by the counsel for the accused respondent, no records have been produced. Wait till 12 exactly. No records have been produced before this court to show that grounds of arrest in writing have been communicated to the family members of the accused to stop. Further, the learned special court in its order in the impugned order dated 18/6/2025 had made the following observation. Page 33. Coming back to the facts of the present case, still has been and this also then after still Constitution of India. Huh? 34 also. 34 Constitution of India. Next slide. The above being said, it would be it would be pertinent to note that in the judgment of the Supreme Court in Bihan, the Honorable Mr. Justice N. Koteshwar Singh had further held that the constitutional mandate of informing the grounds of arrest to the arrested to the grounds of arrest to the person arrested in writing has been explained in the case of Pankaj Bansal so as to be meaningful to serve the intended purpose, which has been reiterated in Prabir Prokais. The said constitutional mandate has been incorporated in the statute under section 50 of the CRPC, bracket section 47 of BNS. While making further while the Supreme Court further while the Honorable Supreme Court further made further observation with the requirements of communicating the grounds of arrest to be purposeful to the friends and relatives of the arrested person as required under section 50 capital A CRPC. In addition to the requirement under section 50 bracket 1 CRPC. It also held that the same was to make the mandate of Article 22 bracket 1 of the Constitution meaningful and effective. Failing which such arrest may be rendered illegal. The Supreme Court thus held that the purpose of communicating the grounds of arrest to the detainee and in addition to his relatives was not a mere formality, but to enable the detained person to know the reasons for his arrest, but to also provide necessary opportunity to his relatives, friends, or nominated person to secure his release at the earliest possible opportunity. for actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. It should also be noted that in terms of, no, it should also be noted that the Supreme Court in Vihan Kumar Supra had held in para 21C that when an arrested accused alleges non-compliance with the requirements of Article 22 bracket 1, comma, the burden will always be on the investigating officer tax agency to prove compliance with the requirements of Article 22 bracket. In the present case, the appellant has not been able to prove that they have complied with the requirements of Article 22. Insofar as communication of the grounds of belief, grounds of arrest of the accused respondent has been communicated to his family members. So, sir, next question. In Darshan, in Sri Darshan, etc. Simple. The Supreme Court has negated the submission of the learned counsel for the accused respondent that an arrest could be illegal if the grounds of arrest were not furnished immediately. Thereby violating Article 22, 1 of the Constitution and Section 50 CRP. Now 47, Section 47 of the bill. However, in the case of Rihan Kumar, the decision of the decision of the Supreme Court there was is to the effect that grounds of arrest has to also be in writing and have to be furnished to the relative of the arrested. And there is in thus there appears that there appears to be dichotomy of views, dichotomy of views in the different decisions of the Supreme Court. However, keeping in view the judgment of the Constitution Bench of the Supreme Court in Pranay Sethi versus Common, wherein it has held that when there are conflicting decisions of equal benches of the Supreme Court, the earlier decision should be followed. They are bound by the decision. We are bound by the earlier decision made by the, which in this case would be Vihan Kumar. So, Now this is subject to your 1 hour
No, it's come lordship.
exam.
It's reached the court campus lordship.
So we leave it at that. Basically, it depending upon what your thing says, your file
Yes,
says.
yes, yes.
It like go and either go this way, otherwise which way?
We are in the tri-junction.
Yes. Other, so this way is already there. Road map is clear. So we have to cut out some.
Lordship. Whatever is there, is there. lordship.
Okay, that is one. We have finished with this. Correct.
But
Now what is the second one?
second case, my lord, after bail, my lord, when I came out from the jail, my lord, from the jail gate, I was again arrested, my lord.
Different case.
Different case.
Different.
That is RC06, my lord. So my contention before the
Pertaining to the same incident.
same incident, if your lordship says that arrest memo, my lord, it says, my lord, 2 persons were killed. The arrest memo, my lord.
इसका वो कहाँ होगा? कहाँ गया? एक मिनट. Yeah.
Now may I submit? My lord, page 56 for our. The order passed by the court. I do.
56.
Page 56, madam. Second paragraph.
Yes.
It is vociferously contended that the action of the arresting authority not only violate the fundamental rights of the accused guaranteed under Article 21 of the Constitution of India, but also the law laid down by the Honorable Supreme Court in Uday Chand's case, where the Honorable Apex Court held that rearrest of an accused person soon after he is being released on bail by a court in connection with a pending criminal case without apprising or disclosing such court granting bail about the pendency of the criminal case, the rearrest becomes illegal. Learned Counsel further contends that our Honorable Guwahati High Court in Dr. A. Loso versus State of Manipur released the accused person on bail following the judgment of the Honorable Apex Court passed in Uday versus Sheikh Mohammed Abdullah. So it is arduous contention of Mr. So-and-so that rearrest of the accused by NIA in the present case immediately after release on bail in another case is illegal, arbitrary, and misuse, my lord. Now, my lord, the court came to a finding, my lord, that your lordship will find at, my lord, page 59, my lord.
Yes.
In the course of argument, Mr. Chaudhary, learned so-and-so, and PP so-and-so, strenuously argued that the arrest of the accused in the present case no way violates the fundamental rights of the accused as alleged because the accused had the prior knowledge about the pendency of both the cases. And this fact has also been intimated to this court in the earlier case, that is FIR number 25, that is 05, earlier case. More so has drawn the attention of this court to the order of the Undersecretary to the Government of India dated 8/2/24, in which both the FIR number 25 of More, my lord, and 26 of More were directed to be investigated by the NIA, and the said document has been in the case record of the court. So there is no question of violation of right of the accused by not informing the court about the pendency of other cases against the accused. Having heard the contention of Chaudhary on careful scanning of both the case record, it transfers that the court has been intimated about the pendency of both the cases against the accused person, of course, not specifically against the accused. But both the affairs were general in nature since some heavily armed suspected Kuki militants attacked the IRB post. Now, they are referring to, my lord, page 19, my lord. If your lordship comes to page 19, 19. Page 19. In the column, my lord, table, my lord, 2 cases were there, my lord. First one is my lord 05, the earlier case, and the second one is my lord RC 06. Well, here, my lord,
Where is 2005?
no, no, it has been,
This is the FIR number only.
yes, my lord, it has been registered as RC 05, the first one. And the second one, my lord, it has been registered as 06 2024, my lord. Now, my lord, going through this, my lord, this order, my lord, nowhere the name of the petitioner appears, my lord. It's an order by the undersecretary of the government, my lord, that NIA should take up both these cases for investigation. There is no whisper of the petitioner's name, my lord, out there, my lord. And moreover, my lord, that
Yes.
and moreover, my lord, that registration. And moreover, my lord, that near registration case number 0524 or RC 0624, it is nowhere mentioned in that. The simple, it's an order, my lord. How can I came to know, my lord, that that I am been involved in another case also, my lord? So in this case, my lord, I am relying, my lord, this Farooq Abdullah's case, my lord, as well as Dr. Loso's case, my lord.
What does it say?
It says, my lord, he should be informed, my lord.
Should be informed.
Yes. No, no, Dr. Loso. Sorry, Abdul.
My question is, can there be two cases on the same incident?
That's one more point, man. Because if your lordship sees the arrest memo,
Is
the
there
gist,
is there any law on that? There might be.
it may be amalgamated at best, man.
Can there be two different FIRs on the same incident?
I don't think so, man.
So where is the citation?
That I'll satisfy man on the next day, man. If your lordship gives me something.
I think there are some judgments.
Yes, yes, man.
There, that Anthony's case is there.
Yes, man. And
I was expecting you to produce those
my lord,
judgments.
actually, man, I was on that point, my lord, because my lord, whether I should be informed, my lord. So I was going
Informed of what? Informed of what?
informed that another case, another criminal case is pending against me.
You have not, the fact that you have got to be informed, no doubt it is required.
But is the,
But the more pertinent issue is whether there can be two FIRs on the same incident.
that's there, my lord. If, then the lordship,
It is the same, nothing.
yes, my lord, then lordship may fix it on my lord Tuesday, my lord. I'll make.
Mr. Chaudhary, can there be two FIRs on the same?
These are two separate incidents.
Two separate incidents.
TT Anthony, my lord.
There are in fact, Lordship, three FIRs who have been shifted to the NIA and one is being done by the state. One is being inquired into by the state of Manipur.
But regarding the same thing,
No, Lordship, the battalion companies are different, the NGOs are different. ये कहाँ गया ना?
Amit.
যেটা it appears to be different.
But here what happened, my lord, once I came out from the jail, my lord, the same arresting person, my lord, or authority, my lord, they neither give me anything, my lord. So when this bail application was filed, my lord, no documents were with us, my lord. So only the point which we raised before the court below is that, my lord, you have to inform us whether any other criminal case is pending against them. And moreover, my lord, if your lord, what is the necessity to arrest? What is the need? That they should have been informed to the court also. And that has been, my lord, reported, my lord, case, my lord, of our court, my lord. Yes. It is a common. Copy does it. And from 2015 one GM. 2015 one GLT page 517.
Eight eight two.
517, man.
Kamal Datta.
Kamal Datta, man.
Yes.
2015 one GLT 517. Actually, well, there are two Kamal Datta's cases. One is regarding compensation.
GLP 483.
No, this is GLT, my lord, 2015 GLT, one GLT, my lord.
2016. 2015 15.
I have given the sheets. Second law.
Kamal Datta.
Yeah.
Which para?
Pain marker. Yes, at a comprehensive.
Kamal Datta was different.
Well, there are two different. There are two cases. This from
Yes,
there is a compensation case.
5/11 2018. You have given a 2015 one.
Yes.
It is 2016. 7 of 2015. Oh, you have given us the wrong way.
Yes, man.
You have given us the wrong
Sorry,
way.
sir.
Yes, what about this?
Well, that pain mark one.
Ah.
And moreover, my lord, 1983 2 SCC is 417.
How does it help?
Stop. এখানে সুবিধা হবে। মানে that Uday Chand's case, my lord, paragraph 5, my lord. Para 5, my lord. Also stated before us that the petitioner were enlarged on bail in pursuance of order passed by this court on March 2, 81. But they were subsequently arrested for some other offences alleged to have been committed by them prior to March 2, 1981. we are quite amazed at this statement, and we should have expected that if after the bail order of bail passed by the authorities of the state considered it fit to arrest any of the petitioner for any offense, it was the bounden duty to apprise this court before taking this person in custody, especially when no disclosure was made to them.
When were you granted bail in the other case? 25,
18,
25,
18/6/25.
18/6/25.
And I came out from the jail on
Or 20, you came out. 26.
26.
And this case has been pending since February 24,
Yes, but
and he did not have a clue. At page 19.
Lordship. Page,
19.
Page
Ba-
19.
yes, page 19 is a order by which the cases were transferred to the NI. Now, these are the cases registered by the state police. After investigation, it is only after investigation that we will come to know about who is involved and who is not. It is not that we will be knowing it on the very first day, because after that we have taken up the investigation, Lordship. And when we have come to know, then we have restricted, Lordship.
What was the basis for investigation?
Lordship.
What was the investigation? What is the basis?
In fact, Lordship, this accused person, he has been identified by the force personnel, Lordship.
Identified when? 1.5 years after the incident.
No, this is an instinct. This is. This is an incident of this year, Lordship.
No, this is
Oh, last year, Lordship.
8 February.
Last year, last year, Lordship. I'm sorry. Yes.
8 February 2024. This
Yes,
was a new
Lordship.
case. Very old.
Oh,
Suddenly someone wakes up and identifies me, is it?
Lordship, he was kept under surveillance, and thereafter, Lordship, he has been.
Mr. Chaudhary, one thing,
Lordship.
he was granted bail on 18th June. So till 18th June, you have no clue that he was involved. It appears. Otherwise, you would have told the court. Unless you were hiding things from the court. So he was granted bail on 18th June. He left the jail on 20th June. So that means you got to know of the sudden development in 19th June or 19th June, correct?
No, Lordship.
He produced the CD.
It's there, Lordship. Is there, Lordship? It's there, Lordship. Because
No, don't show. Just show us When did you come to know about the involvement? Just so that in the document.
And in that objection to no.
Yes, is there, Lordship?
Only in this case, my lord, they have filed an objection, my lord. I think in paragraph 4, my lord, they have stated that from the record.
Let us see.
Objection.
कौन सा उसमें ही है about the new case. Huh? Lordship will give me some time. Lordship is there, but
What about the earlier case?
that is come.
So,
That is come.
we cannot turn the pages please in the relevant page due to the. We cannot turn the. What do you think? We are taking for, Sure. The communication that was received by the brother or the father. From center system. And
Perhaps that is the mail sent to the SP, and that the SP has served that copy.
this is the main, this one is the main thing.
Please. That is the mail sent on 19th.
This is nothing, there's nothing here.
That is sent on mail through the SP of the concerned district to serve.
That is the internal communication. So that.
After that, this copy was received from the SP minutes.
After this,
Please, ma'am.
this is the earlier point in time.
That is, it is at that time, it is very difficult to personally serve. Therefore, we have to be using the police forces of the internal police of the Impal police, Manipur police, my lordship. Therefore, you sent to the concerned SP of district. This accused was arrested here. Therefore, may please be served to the concerned family members. Therefore, after reaching to mail, he have to serve his brother. My lordship, the copy is there.
He was arrested when?
19, my lordship.
19, no. From NIA, zero income. Arrestment, rather, PSP, who is the addressing here?
SP, my lordship. That we sent to the SP.
SP is the father of the accused. Is the SP the father of the
No,
accused?
my lordship,
So,
you have to send to the family member. Again, yes,
So who is the addressee name?
address his brother, my lordship.
What is his name?
We are requesting to serve his any family member, my lordship.
You are requesting to serve, was the request,
Made to the SP concerned, any family member of this accused may be
that is
served.
what we want to see, where.
That copy, my lordship. That is right.
Sir. This is nothing, this does not serve the reason. what is the brother of the accused respondent's name? What is the brother's name?
Father,
Brother of the accused. What is his name?
brother's name, may not. May, may not say he is signed both signature now. His brother.
There is no date.
And let's say they no mention date, but he has mentioned only signature. Accordingly, the SP has to be sent original copy. That is mentioned in the case based melody. His brother name is that signed person name is the Tamilian.
Just give me the document again, the other.
Okay.
You see, there's no date pending the seal. We do not know. Because now there's a contradiction in your objection before the special court. You have said that it was the father. No, nowhere, the father is nowhere there. Now, for the first time, you have come here and said this is the brother.
My lordship, father was by video call intimated. The return was intimated to brother. That is the one that the video is available in the case, my lordship. The intimation and discussion with the through video call by the arrestee and along with this father.
Okay, basically, that's the first case we dismissed. We pass the order. Second,
Second case, my lord. My lord, in the second case, my lord, the objection filed by them in the court below, my lord, that may be produced, my lord, for the court.
where is the objection submitted by you in the, before the section court?
My lordship, that is in the original case record.
Huh?
Original case records. And
Did
I
you
have
get-
copy is there.
If you have submitted the application, you must be having a copy.
My lordship, their appeal made. Second appeal was by.
That objection you filed in the court below,
Huh.
where is that?
You will be having a copy of.
My lord, that,
He
that,
there also served that
well,
copy.
that's what happened, my lord,
It's
that
filed-
file have been misplaced, my lord, because it was done by a, although he was there, my lord, the court. That's why, my
So
lord,
you don't have a copy or,
No, my lordship, I have copy.
let us see. Or what do you want to show?
my lord, there from, it's more or less same, my lord. They say, my lord, in paragraph 4, my lord, that during course of investigation, 10 Manipur police commander personnel was given the statement under 161. So at that point of time, 161 statement was recorded. My lord, 161 means, my lord, July 24, this came, my lord, BNSS. So before it was 161. So on the, on 17, at that point of time, my lord, 161 statements were recorded, my lord. So they have the information regarding this one.
Identified one thing. Huh? We have perused the reports that have been brought by the appellate. Though there is a signature in the arrest memo, in the photocopy of the arrest memo of the accused respondent. Which the appellant say is the signature of the brother of the accused. We find that there is no date affixed to the said signature. On the other hand, all the other signatures in the arrest memo, which has been signed by witnesses and the arrestee and the officer making the arrest, all have dates. In that view of the matter, the submission made by the counsel for the appellant that the brother of the appellant has been given a copy of the arrest memo on 25/20/25 does not inform a copy. Furthermore, as stated earlier, the appellant in the written objection to the bail application before the learned special court in ISM has specifically taken the stand that the grounds of arrest of the accused respondent had been given to the father of the accused respondent. This stand has, however, been completely changed in the present appeal, which has been filed only on the
Filed on 2/6/20.
2/6/2020.
Five.
Is there the above reasons? Or we do not find any ground to interfere with the decision of the learned special court and I said in granting bail to the It may also be worthwhile to mention that in the record, there is nothing to show that the father of the accused respondent has been given the grounds of arrest of the accused. This is accordingly the case. Then item 2. We'll fix it for some other day.
Well,
You give us the copy of the
Right.
written object. Right, on the present party, this is the matter. When?
28th, my lord, Thursday.
28th lordship, I have got some difficulty.
Okay, when you,
Any other day, it's a 28th.
September,
2nd of September. my lord.
2nd of September. Uh, prior to that, yeah, 2nd of September, who's the applicant? Who's the applicant?
He's the appellant.
My answer.
You provide, he doesn't have.
Lordship. In any case, lordship can also call for the scan copy of the records. It will be there.
Do we need to call?
Otherwise,
Well,
I'll find a copy and I'll give it to you, lordship. It's not an issue. Oh, only lordship. Can it be a third lordship? Third or first of, third or first in lordship. Oh, first. Third lordship.
On that day, the learned counsel for the respondent and I shall submit copies of the written objections submitted by them before the learned and I court.
I'm obliged.
Yeah, so it's very fair.
May I please? Well, in this criminal appeal, my lord, I filed an IA, my lord, 439/25 for two-person, my lord, Shahjamal and Sadhual. Two-person, my lord. My lord, in this trial, my lord, altogether 17% has been searched initially, and 3 during the trial expired, my lord. 17, my lord. 3 expired.
17 were charged.
Yes, my lord. And the prime is also expired, my lord. The 3% altogether expired, my lord. Then the conviction, sorry, my 2% expired, 1 been acquitted. And all preferred the appeal, my lord.
So
Before-
that means 15 have preferred appeal.
Yes, my lord. Out of 14, my lord, 12 has already been granted bail by this honorable court. That is page 176, my lord, operating part, my lord, of my memo of appeal, my lord. Page 174 starts in IA, my lord, 1272. Page 174.
Yes.
12 accused person, my lord, they were enlarged on bail, my lord, suspending the sentence now. All, my lord. Now only these two are in custody, my lord. These two appellants.
Right?
At that time, we have not preferred on that day, my lord. We have come subsequently.
Yeah, who is the main accused?
Main accused is one Abdul Ghani. He, Islam Ghani, my lord, he expired during the trial. Now, the allegation is that, my lord, on that fateful day, my lord, what happened? The victim's father and the mother, they were to the fishing, my lord. They went to the fishing, my lord. And then the accused person, my lord, they came in, my lord, and they have assaulted initially the father, the PW2. Then his son came in to interfere. Then he was also been beaten and he succumbed to the injuries, my lord. That is the basic case of the prosecution. Now, against us, the allegation, all the eyewitnesses, who claim to be eyewitnesses, my lord, they said we have instigated other accused to kill him, kill the father, PW2. We have not participated. There is no allegation of participated. All the witnesses has specifically mentioned that we too instigated the other accused to kill the father, PW2. That is what then the son came in and he was beaten. He succumbed to the injuries in the hospital subsequently.
When was this incident?
Incident of my lord. 2021, my lord. 13/5/2021. Now, during that's most important factor of this case, my lord, during the investigation, my lord, the IO could not find anything against the other accused person except one Ghani, my lord, Islam Ghani. That is in the record. So, IO, we filed the charge sheet against only one, that is Islam Ghani. Then during the trial, my lord, after 3 witnesses, my lord, all the accused person has implicated, my lord, under 319. Under the provisions of 319, the trial court invoked that 319 and the other accused person being charged accordingly, my lord, in this case, who has been named in the FIR. But (319) CRPC, my lord, during the trial, if the evidence considering the evidence, the court can summon any of the accused, my lord. So why it has happened actually, my lord? All the witnesses during their first statement under 161, they has not implicated us, man. That is why the IO rightly not sent up those accused person for the trial. And for the first time, we have been implicated in the court, man, for the first time. That is the case, man. Not before the IO. And that's the contradiction has been proved by the IO. So, and apart from that, my lord, the other witnesses also, the prosecution, there are 2 versions in the prosecution. Some of the witnesses, there happens to be the other eyewitnesses, they say that these two, we are not present at the time of alleged occurrence. The other prosecution, the relatives of,
Some of them have said you have.
yes, some of that we have instigated, and some of the prosecution witnesses, we are not the relatives. The relative says that we are present, but the other witnesses, the independent witnesses says we are not present. And there's a plea of alibi also, which has been proved that at the time of incident, because we used to work in some department, we are in the department. So that has been proved, madam. So and all the witnesses, madam, all the witnesses, for the first time, the IO has categorically, the PW14 has said, that you can go through PW14. His evidence is very clear. all the witnesses has implicated us for the first time in the court. And rather the other witnesses said that even the PW 1, 2, 3, 5, 6, they are also not present at the time of occurrence. They came subsequently to the panel.
The paperwork ready.
No, my, no.
PCR evidence.
So all has been granted bail, my lord, considering these aspects, my lord. Prime accused already expired, my lord. Prime accused already expired, my lord, who has given the fatal blow to the deceased, my lord. And our point is only we have instigated, but that is only for the first time before the court. And our presence has been doubtful, that has been created by the prosecution itself. The-
Yes, madam.
Yes, there are eyewitnesses to the occurrence, my lord. All the eyewitnesses, more particularly PW 3, 4, 5, and 6, and 7, they have named the two accused persons
As
who have
well,
implicated these two accused persons, my lord. That they were the masterminds. They've instigated all the PWs who happen to be the eyewitnesses. They have diverse in the court, your lordship, because I am not, lordship, the records are not before me, my lord. Whether in 161 what they have stated and what is substantive evidence.
That is
But
from
they
the
have
IOS.
named, my lord. They have named the accused person. These two accused persons asked the other accused person to kill him, and thereafter all the other accused persons asked to us them. One is injured and one is
no, basically, all of them are guilty.
lordship.
All of them are guilty.
Yes, in that sense.
Relative lordship.
All of them are guilty in that
Guilty,
sense.
in that sense.
I asked someone to, supposing I asked my brother to kill someone, though it doesn't look like it.
But they specifically,
And he killed.
Yes.
I am guilty,
my lord.
he's also guilty.
Yes.
Oh, he
So
would
your
be guilty.
lordship meant to say since the other persons
Yes.
have been, yes, my lord.
Oh.
So in the event of the matter, lordship,
Because
since
everyone
they have
has-
specifically named these two accused persons, my lord, they are the masterminds. Lordship, since the TCR is available, your lordship will please to direct the registry to prepare the paperwork, my lord.
That
Because
we will do.
all the eyewitnesses have lordship deposed before the court. They were specifically, these two accused persons were mastermind. They have instructed the other accused persons to kill. One is injured and one eyewitness is there. One is dead and one is injured, my lord.
You see, we want the guilt, or want the guilt be the same. Not only on the person who orders the execution, but on the person also who does the act.
Yes, and also here 30234 is.
That is what, so if the others have been granted bail, why shouldn't he be granted?
I am just relying on one recent Supreme Court judgment.
My lordship,
89.
that is that apart.
Any criminal antecedent?
No,
of this person?
no, that's not the case.
Entire evidence
No,
on
no.
record, I have not. read.
Lordship, kindly, one thing kindly see, my lord.
Just- let's pick.
Lordship, para 10, 16 and 17, para 10, your lordship. Lordship, para 10, one would have expected a High Court hearing an application under 389 CRPC for suspension of sentence to examine whether prima facie there was anything culpable on the record to indicate if the accused had a fair chance of overwhelming or overturning the conviction. It was reflected and your lordship may see para 33 in that paragraph, subpara. It's a quotation of another judgment. Bearing in mind the aforesaid principles of law, the endeavor on the part of the court therefore should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands for fair chance of acquittal. If the answer to the aforesaid question is to be in the affirmative as a necessary corollary, we shall have to say that if ultimately the convict appears to be entitled to have an acquittal at the hands of the court, he should not be kept in behind the bars for a pretty long time till the conclusion of the appeal, which usually takes very long for decisions of disposal. However, while undertaking the exercise to ascertain whether the convict has clear chances of acquittal, what is to be looked into is something culpable. To put it in other words, something which is very apparent or gross on the face of the record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. The appellate court should not reappreciate the evidence at the stage of section 389 and try to pick up a few lacunae or loopholes here or there. In the case of the prosecution, such would not be a correct approach.
So we're not picking any loopholes.
My lord.
The thing is that when similarly this person have already been granted bail. That's all the thing. Why should these
But these two persons
Are
have
they-
instructed others, my lord. They are the mastermind. That much I can say because this one, lordship, depositions are, lordship is not available. It's not before me. Lordship, only the.
No, my lord, I'm surprised, my lord. I have filed the IA, my lord, along with all the deposition file. And they have filed the objection to that also. That means they, without going through the IA, they have filed the objection.
By somebody else, my
No,
lord.
that's
I
not,
don't blame
that's not the
anyone.
criteria, my lord. Who is somebody else? I'm not concerned about who is somebody else. Every PW, my lordship kindly see one thing. We go by the judgment also. My lord, if we go by the judgment also, then lordship has to see whether there is a case for acquittal or not. If that be so, my lord, lordship kindly see the PW 14.
Okay, right. This is one for the applicant. Also heard the then as senior counsel and additional PT. The present application is an application under section 430.
See it.
69,
Yes,
430, ma'am.
PNS.
430.
430.
For suspension of the sentence. Pass in relation to the that's been an order dated 19/11/2020 by the Sessions Judge South Salmara, Mankata, Assam. In Sessions case number 18 of 2018 of 2021. By which the two applicants along with 14 other 16 other. No, along with 14 other persons have been convicted under section 302 Act 34. Correct, altogether 16 were convicted. Correct, 15.
15, my lord. 15 convicted, my lord.
Oh, that means 13 other. And 13, not 14, 13 other. The counsel for the applicant submits
One by
that the basic case against the appellant is that they were the main instigators to the killing of the deceased. And that the other two accused were only following the directions of the applicant. Next part. The learned counsel for the applicant submit that initially there were 17 accused persons
in the FIR.
in the FIR, out of whom 15 were convicted under section 302 Act 34.
One during trial action.
He also submits that the main accused, Abdul Ghani.
Gani.
He is
Islam
like-
Gani. Islam Gani. Islam Gani.
Islam Ghani, ISLAS-GONI, has expired. In the meantime. Islam Ghani was the person who had inflicted the vital blow to the body of the deceased, which resulted in the death of the deceased. The applicant's counsel submits that
They were not sent up for trial now. We are not sent up for trial initially.
okay, submits that only Abdul Islam Ghani
Yes.
was charged sheet. And the applicants along with 12 other co-accused were not set for trial. It was only due to the directives of the another trial and the section 319 CRP that the applicants along with 12 other co-accused were required to pay. Yes, sir. The learned counsel for the applicant submits that the 12 accused have already approached this court by way of IA Criminal 1272 of 2024, praying for suspension of their sentence and grant of bail. We submit that the same has been allowed by orders dated 10/4/25. Passed in IA Criminal 1272 of 2024. Order will be submitted that the criminal order may be found. In the film, this part, may be where the additional people objects to the application for suspension of the sentence and grant of bail on account of the applicants being the main instigator to the crime in question. We submit that the prosecution witnesses have proved the fact that the crime had been committed due to the directions, instigation of the applicant. And as such, the applicant should be. The applicant, answer the application should be. We have heard the count for the. On a very made bias to the learned counsel with regard to the antecedent of the comment. I have been informed that the applicants do not have any criminal history. Further, in view of the fact that all the applicants, in view of the fact that the applicants and all the other courts have been convicted under the same charge of section 302 Act 34 I. And the sentences have been suspended in respect of the third court. We are of the view that present applicants should also be allowed to be released on bail. Accordingly, the sentence imposed upon the applicant is suspended and they are allowed to speak and they will be released on bail on
Earlier, मतलब
Bail bond.
25,000 each.
on a bail bond of rupees 35,000 to the satisfaction of the
Learned session judge South Salma.
third section judge South Salman.
Mankachar. Oblige man. Hello.
The main case to right. As the TCR has arrived, the registry to prepare the paperwork.
One line and Lordship, please to add, the observation made is that instant IA will not like affect the merit of the case.
Observation we have made. Only observation we have made is that since they have been allowed to go on bail, they should not do. That's all. Nothing on merit.
Oblige.
This is a matter after time. This is a common order, huh? This is a matter after 4 weeks.
Well, I am in item number 4.
Oh, you want your name?
Yes, sir.
Oh, okay. Mr. N.
In
Mahajan appears for the appellant
appellants in item 4, madam.
in item 4 for criminal appeal
442, madam.
442 of 2022.
I am for the informant.
Mr. I. Chaudhary for the informant in the 442 of 2020.
Obliged, madam. May I please, your lordship? My lord, there's been a technical typological error in the application, so my lord, I may be allowed to withdraw the application and give the liberty to file it first.
So Mr. S. Counsel for the applicant. Saying that they may be allowed to withdraw the application with the ability to file a pitch. Whereas allowed, this is the matter. No, application is accordingly dismissed and withdrawn with liberty.
Obliged, madam.
Hello, though this matter is listed in the hearing column, my lord, I urge upon your lordship to see an order dated 29/8/23, wherein certain exercise was directed to be carried out, which was accordingly carried out.
So,
So that needs to pass orders, my lord, on the basis of that report. Whatever it has come, we are not aware because
9.
29/8/23 by Honorable Justice Surana and Malaswin. It's eight order. यहाँ मैं देखा तो इस पर पहले मैंने देखा था इनके सामने से nice copy की वो नीचे दिया मैंने नहीं क्या हम तो नहीं दिया दिया ना इन हो गया एक ताकत थी 29 अगर पीडीएफ की वीडियो तो है 29/8/23
yes, what has happened, madam?
Lordship, I am not aware of as to whether any report has been garnished or not.
no.
Because no
That's
copy-
another order, if your lordship will kindly look into the last order probably, my lord. It was passed by Honorable Justice on 27/5/25. Kumar Keval. Right.
Is there no objection? Copy of the paper book.
My lord, actually what happened, my lord, I was there on that day, my lord. We started the argument, my lord, before the Honorable Court of Justice Surana and Mitali. And at that time it surfaced that there is a plea of juvenility, my lord.
That's all right. I'm not saying the office note of 25/2025, which says that, a copy of inside report has been served.
Oh, yes.
Copy, they have been some, we are not some
Oh, just now I have Lordship.
in it. They have got it, my lord.
What is this? Required report regarding the age.
Juvenility. We are not served with the copy, my lord, so we don't know they have got a copy. The
Let
inquiry
it be on
report.
Monday then. No?
And this is a holiday matter.
Oh, yeah. Mistake.
No, will not be there.
Get a copy of the.
No, is it
Let it come
16/11
tomorrow, madam.
2023? I'm not aware of just now I got in the file.
Kali I got there.
16/11/2023. Is it 16/11/2023?
No,
Order.
Extend it.
order.
Enquiry report.
Inquiry report. Yes, my lord, 16/11/23, as per last order, as per the request of Mr. Kosik, learned APP, registry to furnish a copy of the inquiry report dated 16/11/23 of the additional district and session judge Kamrup to Guwahati within 3 working days. That is there.
Let us see the report.
Yes.
Report to Sabo. Submission কি আছে? If the report says limited, then definitely proceed when applied to. Is the copy, my lord, it will be definitely original in the report.
I've got.
So, I'm going to. This will help producer, we will be same. Yeah, there is one.
You know, there is a.
You know,
18 man. Not only me, man, Mr. Ahmed sir, please come. Put it down.
May I please, your lord, my lord, for the appeal number
Accused name.
78 and 50, my lord. In that,
Who is the accused applicant, can we say?
who is appellant in appeal number 78, my lord,
Kuntu juvenile ko jana?
juvenile Hare Krishna Pal,
Oh.
appeal number 78.
It is there, my lord. Hare Krishna Pal is here.
Hare Krishna Pal.
Our is Porimal Pal.
Lordship, there are judgments to that effect. After 20, 30 years, it's, Lordship, exactly cannot be ascertained. So my learned friend has already noted that in the, I'll go through the judgment and place it before the court on Wednesday, my lord.
Not one Sonju Pal also declared juvenile in appeal number
Sabo.
50, man.
Sabo.
After 17 years, so at least. Open it to the, yes, sir. Yes, sir.
And she will come back, my lord, after going through it, my lord.
21.
He says on first month.
First month. Otherwise tomorrow or on the, then first month.
Then I put the prayer, the.
Day after tomorrow.
The matter on. So you have got the copy of the report.
Yeah,
You don't need.
already served, my lord.
So you
It
don't
can-
need.
Yeah, it can be incorporated in the order, my lord. In terms of the order data such.
Just right, just right, on the prayer, the party, the matter on first.
119, my lord.
The inquiry report regarding the termination of aid of the appellant has been submitted by the additional district judge of the two Kamrup Metro. My letter dated 16/11/2020. It is 23, why is it still here?
But somehow it was not listed, my lord.
It's a matter
Not
of.
a Definitely not of interest in the local. Not in. Intent of only, are not in the. So it will be on 1/9. Much of it.
I don't.
That was it.
How many appellants?
One lordship,
Three,
three lordship. And there
34.
are lordship,
02, 34.
lordship,
Any eyewitnesses?
lordship, this is that should give your lordship. I have got it for the next one, lordship. So she will be there, lordship.
Any witnesses? Eyewitnesses?
Yes,
How many?
2, 3 and 4 and 5.
4 and 5.
Mother and daughter.
Mother and daughters, who
But-
was killed? The
Mother,
son,
no,
Husband.
husband.
husband of
Husband of,
the mother, husband of the
The
mother.
eye
no. Informant,
informant,
Who is the informant?
Nazira Khatun,
Who is she? How is she related to the deceased?
wife, my lord.
Wife.
Husband,
Wife is the
husband was,
informant.
husband was
Wife is the informant, husband was killed. By whom?
by, and there are three appellants, my lord, as a list.
Why? What is the ground?
There's a dispute, my lord,
Land property dispute.
in my lord.
Why they
But
have,
there is no, my lord, independent witness. There is no any independent witness.
no,
my
no,
lord.
independent witness, there's a, you see, independent, you don't, you mean to say interested witness.
My lord.
See, because you see, just because they are family, does not mean that they interested witnesses. Interested witnesses
But
are
they were-
those witnesses
That,
where they want to see the accused go to jail, no matter what.
those independents were not,
Then
not
Annabelle-
corroborated by independent. witness.
Huh?
They are not corroborated by independent witness. Though there were the other witnesses were there. They stated clearly, man. Other witnesses were present at that time, man. None of them included in the
Mother of deceased also injured.
my lord.
Mother of the deceased was injured.
Examine.
She's a eyewitness. So an injured eyewitness, what more do you want?
Just the corroboration, my lord, by any of the independent witness. Only
There is
two.
eyewitness, well, the question of corroboration. One eyewitness is.
And moreover, my lord, the weapons used by the appellant as a liftman. They are not sent to FSL for example.
Anyway, we'll hear you at 2, but you've got an uphill task. It appears. You're on a sticky wicket. Huh? We'll take it up at 2.
lordship.
Legal. May I read the final
Yes, yes.
paper with me? Page 4.
Yes.
To the officer in charge, Kosovo Police Station.
Yes.
My lord, Mustafa Nazira Khatun. Sir, I have the honor to state that around 9 p.m. on 26/13, Thursday, the below named accused persons in connection with this selling of a mango tree dragged my husband Ali Hussein by tying his hands and legs to there within recorded accused persons courtyard and killed him, thereby assaulting him with spear, pieces of wood, and by hacking with dowel. Moreover, they also injured my mother-in-law severely by punching and assaulting her with pieces of wood. I therefore pray to you, take necessary action after investigation into the matter. So this is the affair, my lord.
PW number?
PW 2
Huh?
3
Freeze it, Bob.
seizing for now. Wife for this
What
is
was the deceased?
this is.
Okay, then.
Then my lord, PW 1. Then Mohammed Alauddin. Yes, Caesar witness, my lord. But he is the Nayak of the VDP, page 12, my lord. He stated that I know the accused person, namely Amir Hussain, Iman Hussain, and Sahadan Ali present in the dock, and also accused Mujibur Rahman, who is absent. I know important Mustafa Nazira Khatum. I know deceased or Ali Hussain as well. The incident took place around 2-3 years ago, around 7 to 8 p.m. on day of the incident. Our DTV secretary Aladdin called me and said that Ali Hussain died. He took me to accused Iman Hussein's house along with him. I saw Ali Hussain lying dead with cut injuries on his body in the courtyard of accused Iman Hussein's house, and he was smeared with blood. There was a cut injury in Ali Hussein's neck. The villagers gathered as soon as we arrived there. The VDP secretary informed at the police station over phone. Police arrived. They took Ali Hussein's dead body to the police station. In cross my lord, he said that he earned his living by working in the market. Police did not question me anything about the incident. I did not state in front of the police what I have stated today in the court matter. So this is the deposition of PW1. And Nazira Khatun, who is the informant, wife of the deceased man. She was not there at the time of incident. In cross my lord, at page 15, he stated, the accused persons are my relatives. Nur Banu is the stepmother of the accused persons. I do not know if they had any dispute prior to the incident. I did not witness the incident of fighting. The distance from my husband's house to that of my father's.
Yes, is your husband related to the appellant?
Husband of PW3.
The
Yes,
deceased-
yes.
the deceased-
Yes,
The deceased is the.
yes,
stepbrother.
step brothers.
He's a step.
Yes.
Okay. So the three step brother killed their step brother. The three real brothers
Yes,
killed their step brother.
yes.
This is Alisha Khatun and Noor Banu. Damn it. Doctor and Jamada.
Nilbanu PW4 is.
Yeah, examine.
4 and
At
4 and 5.
4 and 5 again. At page 17, madam. PW5 others for examine. Alisa Khatun. Daughter of the deceased.
No, so this BWD, she did not witness the incident.
No,
No, madam.
it
Only
was somewhere else. It was informed by, which one, no? PW4 and PW5.
madam, kindly come to page 31, madam.
31.
31. The deposition of the Joseph Jedlet SI.
Yes,
In cross mallet, cross section mallet, and the cross portion, the details of the ZD number 521 dated 26/2013 is available in my case diary, but not separately prepared. I went to the place of occurrence at 9:35 p.m. from the PS and arrived at the PO, the place of occurrence, at 9:50 p.m. The distance from the PS to the PO was around 6 kilometers. I have not mentioned in my case diary that the road condition was not good at that time and it was raining. We used motorcycle to go to the PO. I found Alaluddin, Mohibullah Rahimuddin, Saiful, Nur Hussain, and Toibul Rahman. I recorded their statement on the same night at the place of occurrence. Alaluddin showed me the waves. I have not seen the waves in the court today. The police officer stated that my lord, the PW 10 has stated that he has not seen the waves in the court today on that day. Alauddin stated before me that the dead body of Ali Hussein was lying in the campus of Iman Hussein. Alauddin did not state before me that he was taken to the place of occurrence by Rohingya. Alauddin did not state before me that there was injury in the neck, leg, and blood was oozing out of the dead body. Alauddin did not state before me that he saw Manwara at the place of occurrence. Alauddin did not state before me who killed Ali Hussein. Nur Banu did not state before me that after return from market, quarrel took place between Ali Hussein and accused persons. Nur Banu did not state before me that Vanessa and Rubina were present with her at the place of occurrence. Nur Banu did not state before me that Shah Jahan and Mojibu tied Ali Hussein and with rope, but stated to me that the accused person tied Ali Hussein. Nur Banu did not state before me that Iman assaulted Ali Hussein with batam, but stated to me that accused person assaulted him. Nur Banu did not state before me that Iman beat Ali Hussein on his head and that accused Shah Jahan pulled her away. Nur Banu did not state before me that hands and legs of Ali Hussein were cut and that she saw blood on the whole body. Alisa Khatun did not state before me that accused persons tied her father. Alisa Khatun did not state before me that the accused person tied her father and the accused Iman Hussein beat her father with a baton. Alisa Khatun did not state before me that she and her elder brother wanted to go to police station, but accused Shah Jahan brought them back. Alisa Khatun did not state before me that on her return she saw her father lying in the courtyard of Iman Hussein. Alisa Khatun did not state before me that her father sustained injury on neck, head, hands, and legs, but stated to me that he sustained injuries all over his body. It is not a fact that I did not visit the place of occurrence, did not conduct the investigation properly, for which I did not record the statements of other witnesses. It is not a fact that I arrested the accused person only on suspicion. Similarly, but let kindly come to
Let us see what they said. They have said only straight away to the IO. What did they say? What did PW 4 and 5 say?
seventeen. While the PW4, the mother of the deceased, she said that Jainaluddin, Sirajuddin, Saidullah, and others gathered. But their names were not included in the witness list, my lord. Although they were present, my lord. Only this,
Their names were not,
they were included in the witness list, my lord.
names not in the witness too.
Yes, my lord.
Whose names are not in the witness?
Yeah, because my lord, PW4 clearly says that at the time of the incident, Jainaluddin, Sirajuddin, Saidullah, and others gathered there, my lord, at the time of incident. But they were not the witnesses. The IO has not mentioned their names in the.
Whose name was not mentioned?
The others name, my lord, number one, I'm speaking. I'm coming.
If you are coming, then where? Coming where?
The Alaluddin Rahimuddin, my lord. 7. I know the accused persons present in the dock. I also know accused Shah Jahan Ali, who is absent. Informant Nazira Khatun is my daughter-in-law. This is Ali Hussain was my son. The incident occurred about 3 years ago. I remember that the date was the 20th. At around 6 p.m. on the day of incident, Ali Hussein, after returning from the market, engaged in quarreling with the accused person on the road in front of our house. My granddaughters, namely Ayesha, Vanessa, Rovina, and I were nearby. The accused persons were arguing with Ali Hussein. Just at the time, the accused person, namely Shah Jahan and Mujibur, tied Ali Hussein up with a rope and promptly pushed him down onto the road. The accused Iman assaulted Ali Hussein with a baton on his head. Afterwards, accused persons, namely Amir Hussein, Mujibur, and Shahjahan, assaulted him with their hands. Ali Hussein shouted, saying, "Do not assault me, do not assault me." I immediately went near Ali Hussein and threw myself over him. Then accused Shahjahan pulled me away. I fell down as a result. At that moment, accused Iman Hussein hacked Ali Hussein with a dao. I tried to go to the police station, but accused Shahjahan pulled me back. The accused person dragged Ali Hussein to the courtyard of Imran. Then Ali Hussein died. I immediately went to inform my daughter-in-law, Nazira Khatun, along with my granddaughter, Aisha Khatun. Alisa Khatun. My daughter-in-law came with me. In the meantime, Ali Hussein's dead body was taken to the PS. There were 3 cut injuries on Ali Hussein's head, and his hands and legs were also cut. I saw blood on his entire body. Postmortem examination of Ali Hussein was performed. His dead body was returned on the following day. Police recorded my statement. Cross-examination. The accused persons are the sons of my co-wife. Prior to the incident, there was no dispute between us. Many people gathered as hue and cry ensued at the time of the incident.
Oh, why?
Joinaluddin, Sirajuddin, Saidullah, and others gathered. Our house is invisible, and accused person's house are separate. My daughter-in-law, Nazira Khatun, lost the Ezahar with the police station. It is not a fact that I did not stand before the police at the time of the incident. Ali Hussein had arrived from the market, that he got engaged in quarreling with the accused person on the road, and that my granddaughters were with me. It is not a fact that while making statement before the police, I did not state the accused Shahjahan and Mujibur tied Ali Hussein with a rope and pushed him onto the ground. That Iman assaulted him, Ali Hussein, within bracket, with a wooden button, and that the rest of the accused person assaulted him with their hand. It is not a fact that I did not state before the police that when Ali Hussein asked them not to assault him, I threw myself over Ali Hussein to save him, and then Shahjahan pulled me away from there. It is not a fact that I did not state before the police that Iman had assaulted Ali Hussein with dao on his head, and that when I tried to go to the police station, Shahjahan restrained me from going by pulling me. It is not a fact that I did not state before the police that when I returned, I saw the dead body of Ali Hussein in the courtyard of the accused person's house. It is not a fact that I did not state before the police that there was cut injury on Ali Hussein's head, and his legs and hands were also cut, and that blood was oozing. I do not know, and I have also never seen that my daughter-in-law Elizabeth Sahidullah. It is not a fact that my daughter-in-law was in love with Sahidullah. It is not a fact that Sahidullah got Ali Hussein killed by engaging people. It is not a fact that I have adduced all evidence. So this is the deposition of PWD court. Kindly come to page 24, my lord. Mohammed Taibur Rahman, the Caesar witness. I know the accused person present in the dock and accused Shahjahan, who is not present. I also know informant Nazira Khatun, and this is Ali Hussein. The incident occurred about 3 years ago. I am the neighbor of both the parties. I was not present at home at the time of incident. I heard from the people about the incident and that the accused person present today and the one who is not present had murdered Ali Hussein. I heard from the villagers and from my family members that weapons like dao and rod were used in his killing. Police came, finding a rod in one side of the accused person's courtyard. Police is the same. Exhibit 2 is the Caesar list, and Exhibit 2(1) is my signature full government statement. In cross, my lord stated
See, what do you want to say? What is their case? You can read. You can read. You read the two eyewitnesses. The other eyewitnesses are not there.
Mm.
So what do you want to say? Okay.
My lord, the PWD 4 and 5. The mother of the disease and 5 is the daughter of the disease. And they were not examined without any correlation, my lord. So there is only independent witness, my lord.
So there is no corroboration of PW 4 and 5.
For instance. By an independent witness. I am relying upon Supreme Court AR 2001 990, page 990. And as regards, my lord, weapons
Which citation?
AR 2001, my lord,
They are 2001
Supreme Court
report
999,
990
990,
990.
my lord. Okay.
Yes, para?
Supreme Court. As regards, my lord, the recovery of weapons used by the appellant as my lord. I am relying upon AR 2007 Supreme
No,
Court.
no weapons were recovered.
No, my lord, recovered
The weapon recovered.
on that DAO hacked by the appellant
Ah,
was not recovered, my lord. Not produced before the court also.
that was not recovered.
Not recovered.
So what was recovered?
The rod was recovered,
Rod, iron rod.
but not produced before
Is
that.
it iron rod?
I don't know then. It is also there is a with
Page, one page.
wooden piece of wood. These were not produced before the court, ma'am. And not these were not sent to FSL. Well, I'm relying upon AR 2007, Supreme Court 2020.
Which para?
I'm
We have highlighted only the head notes. Head notes have been highlighted. Okay, recovery on disclosure statement, weapon must send. So what is the consequence of not sending the weapon to for defense?
as regards the non-examination of independent witness, my lord, I'm again relying upon 2005, AI 2005, Supreme Court 2110.
Where examination?
There will be 2001 also, 2002 criminal law amendments, 353.
Judgments are you giving? Please, you might have one go. How many judgments do you have?
Your code then.
Four.
Oh, it's second is me.
That's all? So basically, your entire case is that the evidence of PW 4 and 5
And on the
has
basis,
not been corroborated by other evidence.
on the basis, my lord, on the basis of evidence adduced by PW 1 and PW 2, the Caesar list, who has not seen the incident. And on the basis of PW 1 and 2, and not corroborated by any independent witness, and PW 4 and 5, on the basis, these witnesses,
So
these two witnesses.
what is wrong?
They were not corroborated, my lord. There are so many people at the time of incident, my lord.
How much, supposing you go to a football match and there are 40,000 persons watching the football match and you see a goal being scored and only one person is interviewed after that. And he says, yes, I saw the goal being scored in that football match. Does he need corroboration? That's all.
My lord.
Lordship will see whether evidence of PW 4 and 5 whose state evidence is believable or not. Lordship, if it is believable, then your Lordship will appeal the judgment. PW 4 is the murder of the deceased, your Lordship. She is in clear terms of stated Lordship. At around 6 p.m. on the day of incident, Ali Hussein, after returning from the market, engaged in quarreling with the accused person. And on the road in front of our house, my granddaughters, namely Ayesha, Panesha, Rubina, and I were nearby. The accused persons were arguing with Ali Hussein just at the time. Accused persons, namely Shah Jahan and Muzipur, tied Ali Hussein up with a rope and promptly pushed him down into the road. Accused Iman assaulted Ali Hussein with a button on his head. Afterwards, accused person, namely Amir, Mujibur, and Shahjahan, assaulted him with their hands. Ali Hussein shouted, saying, "Don't assault me, don't assault me." I immediately went near Ali Hussein and threw myself over him. Then accused Shahjahan pulled me away. I fell down as a result. At that moment, accused Iman Hussein hacked Ali Hussein with a dao. I tried to go to the police station, but accused Shahjahan pulled me back. The accused persons dragged Ali Hussein to the courtyard of Iman Ali. Lordship, they are the, it has been stated on note that accused persons are the sons of the wife, my lord. But your Lordship, although it was out of the argument that occurrence had taken place, but the victim died instantaneously, your Lordship. And PW 5, who is the daughter, your Lordship, she has also stated in clear terms, my lord. On, at page 22, second line. On the day of incident, while my father was returning from the market, the accused person hurled abuses at him on the road. Immediately, the accused person caught hold of my father. At that time, my grandmother and we with three sisters were nearby. They tied my father. Accused Iman Hussein assaulted my father with a baton. He also assaulted him with a dao. All the accused persons assaulted my father with their hands also. When my grandmother and I tried to go to the police station, accused Shahjahan brought us back. We saw that my father was taken to the courtyard of accused Iman house. My father had died then. Lordship, but from the statement of the IO, my lord, we have stated cross-examination of the IO
Yes.
in between. May I read the entire cross? The details of the GD entry number so and so is available in my case diary, but not separately prepared. I went to the place of occurrence at 9:35 p.m. from the PS and arrived at PO 9:50. The distance from the PS to the PO was around 6 kilometers. I have not mentioned in my case diary that the road condition was not good at that time and it was raining. We used motorcycle to go to the PO. I found Alauddin, Mohibuddin, Rahimuddin, Saiful, Nur Hussain, Taibur Rahman, so and so. I recorded their statements on the same night at the place of occurrence. Alauddin showed me the wage. I have not seen the wage in the court today. Alaluddin stated before me that the dead body of Ali Hussein was lying in the campus of Iman Hussein. And who is one of the accused. Dead body is lying there, my lord. Alaluddin did not state before me that he was taken to the place of occurrence by Rohimuddin. Alaluddin did not state before me. So as regards Nur Bhanu and as regards the statement made by PW 4 and 5, Lordship, he has stated Nur Banu did not state before me that after return from market, quarrel took place between Ali Hussein and accused person. Nur Banu did not state before me that Vanessa and Rabina were present with her at the place of occurrence. Nur Banu did not state before me that Shahjahan and Mojibur tied Ali Hussein with rope, but stated to me that the accused person tied Ali Hussein. Nur Banu did not state before me that Iman assaulted Ali Hussein with button, but stated to me that accused persons assaulted him. Lordship, let us see the 160 statement once, whether the evidence given by the IO is correct or not. No? This is Muhammad Ali Hussein is my statement of Nur Bhanu, my lord, is my son, and the accused Muhammad Iman Hussein and Muhammad Amir Hussein are my stepsons, and the others are my in-laws. At the time of the incident, from over 6:30 p.m., I was at the spot, and there was a slight quarreling over family matters and mango tree issue. Then the accused person tied my son Muhammad Ali Hussein and started assaulting him. Later than at about 9 p.m., my son Muhammad Ali Hussein succumbed to his injuries as a result of the assault. My niece Muhammad Alisha Khatun was with me. Then I cried out for help. Later take my niece and went to Hakotik village to inform my daughter-in-law, who went to visit to her parents. I left the dead body at the spot, and later on, she informed, categorically stated, although your lordship was, yes.
So statement of IO is wrong.
He has said, my lord, although she has not named,
Suggestion was admitted
my lord,
by the IO.
my lord.
But that that belies by the what he was doing.
My lord.
So the witness could not be disputed.
Lordship.
That's all.
Lordship, evidence of eyewitnesses, trust or your lordship. 4 accused persons, 1 died, so there are 3.
For a few,
One case against was abated, your lordship, against 1.
that during trial.
It was not recorded, but it was reflected, it's abated now. Iman, let us see. Amir Hussain. At page 84, it's reflected. First paragraph, last line.
He died during trial.
Yes, the case of the accused Amir Hussain is abated on 30. But his 313 is there.
Third, Mr.
Yes, you go.
Yes, we go with. That is passed for the. After I had appellants,
Evidence.
after I had with people and the. Hearing of total judgment.
Evidence.
Yes,
May it please, your lordship.
this is under.
Under
376.
376. Yeah,
It's called.
yes, lordship.
It's not appeal like.
But, lordship, I will take your lordship to.
Mention item number
Item,
number 3.
yes,
So I am seeking an adjournment.
what?
My senior has been having some personal difficulties. The short date.
Who is the counsel for the, in the, yes,
Yes, Lord.
that is with regard to the case. Have you given the wages?
Yeah, wages have been paid, your
Till
lordship.
July,
Yesterday, wages have been paid.
paid,
Yes.
then we can dispose of the entire matter. You're not ready.
But your lordship, don't we have to submit that the wages have been paid?
I believe what you say, you have. If you think that you don't have a very truthful looking face, that's a different thing. But you are not ready.
I have to take the instruction from my senior.
Okay, we'll list it next week.
Yes, next.
We'll dispose it off.
Yes. It can be disposed to those. No, let me take the instruction.
Instructions regarding,
So
instructions regarding what?
telling,
Instructions regarding what?
no, regarding the disposal, anything. Maybe my senior has something to say before that. I'm not aware of it.
Mr.
KJ Hazare.
J. Hazarikan doesn't counsel for the purpose that the wages till July 2025, is it?
Yes.
June or July?
I guess July or not.
Subject that the wages, that the up-to-date wages of the respondent has been paid. Mr.
K. Bhattacharya, on behalf of KL.
Mr. K. Bhattacharya,
Bhattacharya,
on behalf of Mr.
KL.
KL Gupta, counsel for the
Respondent number 1.
respondent number 1. For the petition. Respondent number 1 subjects that we need time to obtain instruction. State that the matter may be listed in the next week. This is the
Your
matter.
lordship, the matter will be listed in September.
Why?
My senior might not be available now.
Okay, when? Look, I want to dispose, I don't want to keep this partner. Basically, it's a small issue. Next week. This is the matter. On Thursday. Thursday.
Lots of recall. This is that JV account matter,
Yes,
Jiribong.
yes.
Yes, yes.
Now what is to be done here?
Yes, on the last occasion, Lordship will have the order,
Ah.
which is with the contempt petition of your Lordship's file. Yes,
Yeah, last order is here.
yes. Now,
Something to do with the railway.
yes, the instruction we have
Ah.
is that there is no settlement talks also. The statement made by yes, Lordship will have that.
This is by the CE, the railway authority, the letter date 13/8 at para 3, my lord. Para 3, they are very clear that money is only to be paid to the JB account and nowhere else. So they have directed us to settle the matter amicably, my lord, at para 4.
So
My lord, now there it is,
now you see, if you are not complying with if you are not settling the matter. what
no,
can
my
the
lord,
court do?
we are very sincere and diligent, my lord. We are very
That is not
earnestly
the
trying.
issue, that is not the issue. That is not the issue whether you are diligent or not diligent. The issue is that when you are, now who is to decide? As
Yes,
to whether the.
Lordship put that question to us, Lordship, on the last occasion.
Ah.
Lordship will please have my application, IA. Now, this document was already showed to your Lordship multiple times, not once. At page 19.
Yes.
Yes, not 19, I'm sorry. It is at page 24. This is part of the EPC contract,
Yes,
1.5.2.
yes,
Now, I'm not reading the whole paragraph. Lordship will kindly see the last portion,
yes,
last sentence. The authority shall have, authority meaning the railway, shall have the right to release payments solely to the lead member. So the lead member is me, 51%, Bromos, and shall not in any manner be responsible and liable for the inter se allocation of payments among members of the consortium JV. So the railway is not concerned at all
no, that is all right.
with, yes.
Your
So the
fault.
railway will make the payment to the lead member. So
No,
the
no,
mechanism is already there.
No, the issue was, why isn't the bank account being made?
That's what, Lordship. Now your Lordship will kindly have the 16.7 order. That is with my IA application, my,
16.7 or?
yes, 16.7 order.
Yes.
Now in court, Lordship will find that they had signed the form,
Yeah.
the current account form. Outside court, when they went outside court, they said that no, we will not sign, because that form requires multiple signatures on several pages. He just signed on the first or second page in court. Outside court, he's saying that no, I will not sign. And why? The reason is that they want the third partner, which is Altis, to be thrown out.
No, it is not.
Just a moment, sir. That's what they told us. And that's the reason given for not signing the JV account form. So therefore, Lordship will see the conduct of the party.
Well, Altis is a sleeping partner.
Just a moment.
They want
The
to
court
make,
put-
wait,
The court put the
They-
question to me.
they,
Just a minute.
Yes. So now your Lordship will kindly see the conduct of the parties. They filed a writ petition asking for a JV account to be formed. Now, I have no objection to that. Whatever, I mean, they went behind my back, issued me no notice. I didn't appear on the first day the order was passed. I have no misgivings about that at this moment. Anyhow, I filed the IA. Now, I'm also asking for the same thing. I'm asking for the JV account to be formed and the payments to be made there. What is the difficulty? But they don't want to sign it. And the reason is actually that. They will not tell that to your Lordship, but that reason is actually that. And for this, they have been making me going round and round all over, but actually they will not sign the JV account form.
Where is the JV account for?
Yes.
Where
My
do they
lord.
have to sign?
Yes. It's marked lordship in pencil. I have a flag mark also. Promos and Altus has signed it.
Right.
Yes.
This pencil has not been signed.
Yes. Before 12 July, I have signed. Only he is left to be signed. Now,
Yes,
My lord. My lord, may I kindly put
I
a
haven't
question?
finished. There's something else I want to show. There's something else I want to show.
yes.
Lordship will see also that there was earlier on, at the very outset, Lordship, there was a power attorney given to me by both Altus and KTC, saying that all the payments will be made to the lead member.
Correct.
Lead member. So there was no difficulty for that. So until unless, I mean, the JV account is being formed, it can go to the lead member and the lead member will distribute proportionately. There is no difficulty with that. And what is happening is that people can see the project. The project is a central government project. It's a very important project. Northeast Frontier Railway from Jiribam to None.
So what do you want?
So therefore, Lordship, they are trying to sabotage and hijack the project. They want to be actually 49% member. This is the actual reality.
Now, the thing is this,
Yes,
I will record your statement
yes.
and if you don't sign this on the next day,
My
or
lord,
previous day,
Lordship.
you don't sign this, then the order goes.
my lord, may just give me 1 minute. My lord, the previous payments that the railways have made, in spite of the order, they made a payment of 37 crores. Whether till date they have distributed the money to us,
Mr.
they have not
Counsel,
done.
I'm not on that. I'm not on whether payments should go to you or this. The entire issue was basically with regard to opening up of a
My-
joint account
my-
as per the agreement made between the three of them.
My lord.
Now, I have directed that, this court has directed that a joint account should be opened. Now, the entire projection of yours earlier,
Because
but that you were not signing,
no, my lord,
that they were not signing. Now it has come to light that you are not signing.
no, my lord, because the operation of the account,
Huh?
because what they have done,
Operation, I'm not.
because they,
That is something, you see, this is not the issue before this court.
My lord-
The issue before this court is only the,
Very true.
the agreement to have a joint account. How it is to be operated,
no, my lord, they are,
That is the-
they are siphoning of the money, my lord,
you go in arbitration, there's arbitration.
no,
Is there an arbitration clause?
no, my lord, there's no.
There's no arbitration,
No,
then you file a case.
No, for that,
You file, there must be a,
for that, we have already moved the civil court for reclaiming the amount, my lord. The amount, what they are doing, they're taking it, they're siphoning of the amount, my lord.
I think,
That ground have not been taken in writ petition. How can we?
correct, that's what.
So after that, today we open the JP account, all the money will go to the proportionate share which we have received. Whatever the ratio of.
You sign this or it goes the next day, everything goes. I'll recall the order. So much.
Well, that is the crux of the thing, my lord. We have been deprived of my work, my
Mr.
lord.
Counsel, you first sign this document. You come to this court and you ask for your agreement to be enforced.
My lord, diligently,
And this court had given order on the
My
first day without issuing any
my
notice.
lord, my lord.
Now it has come to light that you are not signing the document for creating the new account.
My
Why
lord,
shouldn't you be, why shouldn't
my
you
lord, we are
be?
deprived of our rightful share, my lord.
No, that is a different issue. That issue was not the issue in this case.
My lord.
The issue in this case was with regard to opening of a joint.
JB account,
If
which
you
were
want,
ready,
I'll write a detailed order
my lord.
and I will do that and I will impose heavy cost upon you.
No, my lord, my lord,
I
my
will
lord,
impose
kindly-
a heavy cost upon you.
no, my lord, because we are already, because my party was here, my lord, to sign the JB account, my lord.
No, that's incorrect.
My lord, let all the parties come here, they'll sign it here.
No, why?
They have signed it.
I've-
We have signed everything.
Yes,
They have signed everything. Now, I have seen out here their signature and their seal.
Because
Now,
first
I have not seen your signature.
no, because of the very fact that, my lord, they are, they and Ortiz, they have got together and they're opening the account.
What got
themselves
together?
And
We
siphoning
got
of them.
together from the beginning.
You see, no, you see one thing.
I'm sorry.
Everything was being done on the basis of your statement, which is what
My lord, we still.
and no notice was issued on.
My lord.
And now, since I'm hearing this from the other
My lord,
side,
we'll sign
now
the,
I am having second thoughts.
no, my lord, we'll sign
Why
the,
should
we'll
I,
sign
why
the
should
account.
this court go into an issue which might require to be decided by
My
civil
lord,
court?
no, my lord, we'll sign
I-
the,
I- huh, I
my
will-
my
I
lord,
will-
we'll sign the bank form, but my lord may protect us also. May protect us also, my lord.
The question is not that. The question is only with
Because
regard to
My lord,
the agreement signed between
because
us.
previous amount also they have not given to us.
That is a different.
They have not given us a share.
That is a different issue. You see, he has made a statement just now that henceforth all bills will be paid on the new account.
New account, my lord.
Then, but what do you want? You're hearing it from the horse's mouth. You want to hear it from the president? or
That is
something?
there, my lord.
Then, what more? You are playing a game, which, it appears to me that you are playing a game with the court.
No,
That's
no,
right.
no, my lord.
And,
That,
if,
their audacity we don't have.
I don't know, I do not know, depending. You might be having, your clients might be having the audacity to do that.
My lord, they,
And I'm getting the impression now that there might be some truth in
no,
it
because we have been deprived of a rightful share, my lord.
about that. That is not the issue.
Not a single penny has come into my account, because we have been doing the work, but we have not, we've been deprived.
Fine, you do your part.
We'll do that. I'll do
You
my
do
part.
your part.
I'll do my part.
When?
Before the next date, I'll do my part, my lord. But my lord also may protect.
I will, this next week, this matter, let them sign by them.
My
End
lord.
of the matter.
My lord. My lord.
Just a moment.
We'll sign it, my lord, then.
Lordship, we have
Yeah.
also given a declaration.
Please, my lord, whether that money will ultimately come to us.
No, that is a different issue.
There is, but it is the advantage they're taking, my lord.
Look,
We are,
orders have been passed
My lord.
on your submission.
My lord. But
Please do not take advantage.
No, and very sincerely, we are all here, my lord. The clients were here to sign it, my lord. They have come all the way from, my lord.
The conflict always was relaxed for them. Just in the interest of the project. The money to do the.
Yeah, and on the next date, if not done, I am recalling all the orders. You can go in a piece. All the orders, and I will ask them to go and fight it out in the civil court.
We'll sign it before the next date, my lord. Then
You have to do
my lord may protect us, my lord, after that.
You are not doing anything here. I can see straight in front of me. All these documents not signed.
so one request may I make, they may sign in the court premises, because outside, I mean, they may say anything.
Okay. You come.
All the parties may come.
No,
Have time.
we have already signed
You
it,
don't,
We have not.
you sign.
and there is some.
You show, you see where they have to sign. Give it to them. And if they have not signed, you sign it in the meantime.
We will sign up before that. My lord, may give us 1 week. Within 1 week, we'll sign. Let them come and sign it here itself. Or they can sign it outside also in the office also. There's no problem.
We have already signed it.
No, next day is not signed. I'm throwing everything open. They can go to
My
the
lord.
division bench.
My lord.
Everything will be open. This is not the way to do it.
My lord, kindly give us 10 days, my lord. Within that, we'll finish out the business.
Correct. Correct, Mr. R. Sharma, Learned Senior Counsel. For the, for the, for the K, what is this?
KTL, my lord.
K,
KPC.
APC,
Kadamba transaction and construction.
for the KTC. And Mr.
Galib Kabir Manoj.
Howard,
GALIBKABIR.
for this one, for the.
For Dromos
For Dromos.
applicant.
Huh. For MS Dromos Engineer and Contractual. KPC had approached this court by way of WPC 2974 of 2020. In that, the railway should not make any further payment in the individual bank account of Dromos. And instead, direct the respondent number 5 to open a JV account along with the other partners, that is KTC and Altis ALPIS. This court, provide order dated 35/2025. Had held that in view of the decision of the joint meeting held on 9/5/2025. Wherein KPC, Altis and Dromos were present, correct? Yes. And the letter dated 25/5/25 issued by Altis, comma, any payments to be made by the railway authority on the EPC contract would have to be deposited henceforth in the joint venture account to be opened by the MSDECPL ATC ALPIS JV. Subsequent to the above direction passed in the order dated 30/05/25 in WPC 2974 of 2020. The present application has been filed by KPC.
Dromos
Huh?
has filed the application.
Yeah. Dromos. By This is a, hey. Okay.
He had been filed by Domo.
By promos, engineer and contractor, private limited. Praying for a clarification of the order dated 30/05/25. Passed in WPC 2974 of 2025. To the extent that till the joint venture account was opened, the railway authority should be directed to make payment of the EPC contract in the account of the lead member of the JV, that is Bromos. Ah. On the other hand, MSKTC has filed contempt case C 344 of 2021. Praying for initiating contempt proceeding against the railway authority for making payment. Is it? For making payment to Dromos despite the order passed in WPC 2974 of 2020. 2025. Today, the Council for Dromos has submitted a copy of the application form for opening a bank account, showing the signatures made by Dromos and Alpist for opening a JV account. It has also been brought to the notice of this court that despite MSKTC making submissions before this court that the JV account needs to be opened. It is the KTC which has actually been the culprit for not opening the JV account. In as much as they have not given their signature, given the required signature in the application form for opening the JV. Next slide. On perusing the application form, this court is of the view of the tentative view that KTC has not been fair in its dealing with this court. And if they are not interested in giving their signature for opening of a JV account, this court would have to reconsider the order passed earlier, as that could have been a result of not coming to court with reason. This is a matter on. When?
10 days.
Shorter than that, because the entire project is actually.
21. Tell me a date. 21.
When do?
Give me a date.
Seven days, lots of within 7 days.
Today is what date? Today is
25th is a
a
holiday.
matter of 21. 28.
Very,
28 days. And this is a matter of 28.
very.
By which date? It is expected that KTC would have signed the application form for opening a JV bank account.
Just one more thing, Lordship. Can you come to the court premises and sign it, because otherwise,
In the court premise,
My lord, if they have to sign it, they sign it
let
anywhere.
them sign it anyway. If they
They
don't,
sign
if
it
it is
anyway,
not
they only
signed,
need the signatures.
I will take out all. I will recall all the orders.
my lord, my lord.
What do I say? Or you can bring it also and show me that has not been signed.
Very,
The account, first up. At this stage, Mr. Hey Gupta, Leonard Council for the Railways submits that in terms of the order passed in the writ petition, no payments have been made to the have been made to the contractors,
This is after the order.
to the contractors.
there.
Beyond the third, beyond the third. Beyond the third. It submits that all future bills will be paid to the joint venture account if the same is open. List the matter on safety.
so and you
Tell your clients to sign.
My lord, they will sign. My lord.
Then the,
Ultimately, the money doesn't come to me. That is the same, my lord. It does not come to.
no, the issue is not that.
Will
The
not come.
issue is you had paid for a.
My lord, no,
Hey.
my lord, no, my lord, I'm not on that. What is that? They're taking
That-
advantage of paying me
That
my
is a
due share.
different issue. That is a different issue. For that,
That is what we were
that
on.
is the different. Whether it will lie with regard to your money dispute.
No, it doesn't matter. That doesn't. But that is the advantage they have been taking, but they're not paying us a due share.
you file the writ, what's the advantage? I will take it.
Look, your prayer was for a joint venture.
Joint venture account.
On the first day, this
My lord,
had passed
my
around.
lord.
What more do you want? Now you're complaining. What the order you wanted, you're complaining. You're not,
No, my lord will sign it,
making it
will
happen.
sign, but ultimately will not get the money. We know that.
I don't.
No, my lord, not at this stage, because my lord. No, my lord,
Okay, right.
until the next date, my lord, until the next date, because my lord, I have that, my lord, my kindly, my lord,
Right. Heard this. No, for the. Also heard me saying. On considering. The order dated. Spencer passed today's order in the IA. The. This court will have the rule that no case of contempt has been made according to the contempt that against has been. Right.
So I look
Oblige,
like
ma'am.
May I please, your lordship? Lordship, this IA is for correction of order. My lord may find the paragraph 8 at page 13, my lord. Item 2, my lord. Lordship, para 8 at page 13, my lord. May I read the- In view of the consent of parties, the chairman of the board of trustees in the IA, man.
Para eight
At
is,
page 13.
that's the present application.
My lord, page 13, your lordship's order, man. The correction.
Yes,
In view of the consent of the parties, lordship, what?
yes.
The chairman of the board of trustees, Assam Tea and Employment Provident Fund Organization shall fix a date for meeting to be held with the petition.
Just forward, just forward, just forward to my. The contempt, we're not closing the contempt now. On the next date, we'll close the contempt.
Very good.
We'll close the contempt on the next date.
Very good.
No, IA is not finding, contempt is not finding the IA. No, that is wrongly.
Wrongly-
IA was filed subsequently.
So it's.
Contempt was not filed.
Okay, then it. Hello.
Not in the, yes,
Okay. Yes,
Lordship, para 8 at page 13.
yes.
In view of the consent of the parties, the chairman of the board of trustees, Assam Tea and Employment Provident Fund Organization, shall fix a date for a meeting to be held with the petitioner. My lord, this, as per the act, my lord, the authority is with the authorized officer and not the chairman of the
But
board.
that is what your prayer was.
My lord, but
That
the,
is what your prayer was on the last day.
my lord, when we approach the authority is with the authorized officer as per the act. My lord.
What does it say?
Page 243. My lord.
No, where is your approach to the authority?
My lord,
Where have you approached the authorities?
my lord, no meeting,
No, you go and approach the authority.
my lord.
There's
The,
nothing wrong with this order. We cannot.
my lord, only the word should be authorized officer instead of chairman board of trustees. My lord, at page 243 of the act. Notwithstanding 15E, my lord. Notwithstanding the fact that a certificate has been issued by the authorized officer, my lord. So the authorized officer is the authority to look after all the stay of proceedings, amendment, withdrawal, other modes of recovery. Only the word, my lord.
No, that give me the written. What was the challenge?
My lord, that was with regard to the,
You are with the impugn notice of attachment.
yes, my lord.
This is 35. So this impugn notice of attachment is issued by whom?
Recovery officer, my lord. At page 47 of the repetition. Well, the direction is to be issued from the authorized officer. Page 47, my lord, the author of attachments.
Yes, what is to be done?
Lordship, because they have, the representation has to be made. So it is to be authorized officer, or your lordship can replace the word chairman with authorized officer, or your lordship can also add, or any other officer authorized under the act. That's all. The condemnation has to be done by the authorized.
Then where did this word come from? Chairman, Board of Trustees, where did it come from?
It's one of the parties in the relationship. Right.
But where is your letter
Lordship,
to them?
my lord, we approached them with the certified copy, but we, as the authorized officer is the concerned authority as per the act.
Well, I distinctly remember you said you all had asked for the chairman to decide. That was slightly
My lord,
typical
chairman,
also, but then that's what you all have decided.
all the letters are issued, demand notices are issued by the recovery officer, my lord, who is authorized by the authorized officer. It's written in the act, my lord, section 15E1, my lord.
How much money have you paid?
My lord, to that extent, I have to take the instruction. My lord, 75 lakhs were paid on the date of disposal of the writ petition, that is 18/7, my lord. Thereafter,
You were supposed to pay 100 lakhs by July 2025.
lordship, on 18/7, I had the instructions of 75 lakhs. Thereafter, my lord, the 13 days, I have no instructions with regard to the same.
You provided permission, right, Mr.
M. Sahewala.
Saiwala, then passes for the applicant. Submits that. As on 18/7/2025, rupees 75 lakhs. Out of
3.97.
3.974 has been paid. Pursuant to the order dated 18/7/2025. Passed in WPC. 3 of credit. It is seen that in terms of the said order, rupees 1 crore was to be paid by July 2020. Mr. M. Saiwala can obtain instructions with regard to the same. This is the matter. When?
My lord. Monday, Tuesday, any day.
Mr.
Action.
Sharma appears for the
Just one. All the rest.
all the stuff. Bring that information.
Apart from one, my lordship. 2, 3, 4.
All the rest appears for response number 2 to 4. So you give that one crore. You need that.
Look. Okay, sir.
Yes, what is that case?
But, we have filed the additional affidavit, my lord, the annexer, flag G, flag G.
Oh, yeah, okay.
Yes, flag G, my lord. We have filed the additional affidavit, my lord.
What to do? There's no one here.
They have, Lord Sand has gone to court number 9, my lord. He has told me.
Flag G.
Flag G. I'm, Nasu got it? May I read, my lord, paragraph? That the deponent has to state that the deponent has filed the certain documents of selection process conducted by the district level selection committee Kachar in the year 2005-6. The office of the DE Assam by letter dated 11/4/2025 has instructed the government advocate that the documents are not genuine. It is further stated that the DEO Kachar has never submitted the documents of school-wise screening committee. In this regard, it is stated that this honorable court, after filing of the additional affidavit, allowed the government advocate to take instruction from the custodian of the records. But the perusal of the last paragraph of the letter dated 11/4/2025 goes to show that the DE Assam has never inquired with the office of the DEO Kachar with regard to the authenticity of the documents, but stated that the documents produced by the petitioner with the additional affidavit are manipulated documents. Otherwise, the DEO Kachar would have submitted the said documents had this been available with him at that period of time. In this regard, it is further clarified that as per the direction of this honorable court dated 12/7/2018, passed in WPC number 36 and others, the office of the DE Assam has conducted inquiry and issued a letter dated 9/10/2018, Annexure 7A, whereby the DE Assam has directed the then DEO Kachar to bring all records available in the office along with the concerned dealing assistant with the office file along with the DEO Kachar. And further, all the headmaster and headmistress of the schools concerned had been directed to be present before the inquiry committee. After conducting the inquiry and verification of all documents, and in the said inquiry, the marks obtained in the interview had also been collected, and thereafter it reveals from the inquiry report that during the course of verification, individual school-wise reports submitted by the then DEO Kachar had been verified. The report of the headmaster concerned, who are ex officio member secretary, had also been taken into consideration. It is therefore evident from the record that the office of the DEO.
How do you prove all this? No?
Yes, I'm reading, my lord. These documents are there in this proceedings. It's annexed already.
Where?
Yes, I'm coming, my lord. Let me just clarify, my lord. It is therefore evident from record that the office of the DE Assam, through this instruction dated 11/4/2025 has. Yes, sir. Annexer, let me just read, my lord, paragraph 4 once, my lord. Yes. An additional affidavit number 2, my lord, it is there. And the writ petition, my lord. And it's at 10A, page 92. This is the report, my lord, submitted by the then director to the secretary, my lord.
I want to see the document where that has been signed.
Assignment, it is given in additional affidavit number 2, my lord.
See, is it these, what you say, what they say now?
Page number 233, my lord, that there is the select list signed by the district element education officer Tinshukia, who only single signature, that in respect of Tinshukia district, my lord, it is annexed.
Your case is with regard to which district?
At the Kachar district, for there.
So what is this 233? This is with regard to Tinsukia.
Yes.
We are not bothered with it.
My lord, that they have stated in our case, my lord, that only district officers signed the selection list, therefore they are not going to act upon. But in respect of Tinsukia district also, my lord, the only we could procure it. Only the district officer has signed it, my lord, and they have been appointed. And my lord, we have through the additional affidavit number.
But the selection committee consisted of 3%.
Yes. So, it is as per the, my lord, as per the guideline itself, my lord. It is there, my lord, after the selection is over, or the pro forma is given with regard to address, and who will be selected has to be submitted only. Not the entire, my lord. And the director himself, my lord, conducted the inquiry after the direction of this honorable court. And in the inquiry, he has called for all the teachers and all district officers and all authorities who were, my lord, at that point of time in charge of the selection process. And they have, and the list which was sent by the district elementary officer in the year 2011, that has already been verified in the inquiry, my lord, by the director.
So you see, so the selection was made for all the districts.
Yes, yes.
Now for all the districts, there were 3 signatures, except for Tinsukia and your.
All the districts, we do not have the records, my lord. We do not have the records. We could not procure it because the records are with the director office, my lord. But Tinsukia, my lord, they have sent one. We could procure it. That's why we could submit it, my lord. And the additional documents, they are saying that there was no interview at all. That is not correct. And except 10 and 10B, but the report of the director itself is an admitted fact on record, my lord. There was interview. They have given the specific dates of the interview also, my lord. Interview was, my lord, in annexure 10A, my lord, it is given interview held on, my lord, 30/12/2025. 31/12/2005, 2/1/2006, 4/1/2006, and 8/1/2006. It is given in their report by the director. Director of in the proposal, there what
What to do when they don't have the?
they are, my lord, it is not, they are not producing. That is the thing.
what
Well,
to do?
your lordship will direct them to, my lord, to act upon the report of inquiry report, my lord, given by the director. Selection list published by the director. Otherwise, these people have no fault on their part. All over Assam, they have appointed, my lord.
But those appointments have been made on the basis of, there was no problem with regard to the selection. All the signatures were given.
No, all the signatures, only the district elementations are forwarded, my lord, that we could procure in every case so far as our information is concerned. But in respect of Kachar district, my lord, they have not acted upon, my lord. That is the thing. And we have tried our level best to establish, my lord, that even the director in his reply, which is record part of the record, my lord, Annex 10A and 10B, submitted to the government, has stated himself that this interview took place on such and such date, and we have found it genuine. Everything was there.
They are
Annex 10 and 10B, my lord, the letters,
saying,
page 92 and 97, my lord. Annex 10. Page 92, paragraph 3, my lord. According to the head teacher, headmasters of LP, UP schools of Kachar district published advertisement for filling up the post of that filling up the vacant post of grateful officer of the school. Subsequently, interview held on 30/12/2005, 31/12/2005, 2/1/2006, 4/1/2006, and 8/1/2006 for filling up the post of grateful in officers. This is the letter written in 2019, my lord, by the director to the secretary.
maybe, but then there was a written exam also. No?
There's no written examination.
No.
No.
But that interview, in the interview, so it's only interview mark.
Yes, interview.
Interview mark, but then in the interview mark, there was only the signature of one person.
No. Interview sheet, my lord, was prepared school-wise where all the members have put their signatures. On the basis of those sheets, there was a consolidated statement. As per the guideline, only the consolidated statement has to be sent by the authority to the director, not the entire, all the documents. Not all the documents, my lord. Page 34, my lord, after paragraph 2. After interview, the screening committee will have to prepare a consolidated list in order of performance with detailed particulars of candidates like postal address, qualifications,
No,
and
but you
experience.
see, the select list
Yes.
is to contain the signatures of all the screening committee.
These select lists were never forwarded to the office of the director in all the districts. Only the consolidated statement was forwarded against each school. Such and such candidate selected, and its address.
Yes. What
That is the crux of the issue, my lord.
Huh?
That is the crux of the issue. Page 128. Page 128 in our affidavit, my lord. We have conducted a thorough inquiry, my lord, regarding Kachar district, my lord. And this is the finding of the inquiry.
Yeah.
Page 128, finding of the inquiry committee and additional facts that have emerged from the inquiry. All the district constituted the screening committees as stipulated by the Director of Elementary Education, Assam, which then published an advertisement and proved the interviews. All the districts then submitted the selected list of the candidates by putting signature of all the members of the screening committee. That is the headmaster, mistress, head pandits as the member secretary, the deputy inspector of schools as member, and the DEO as the chairman while preparing the school-wise list and the consolidated list. On the other hand, Kasar district had submitted their list only under the signature of the DEO, both in school-wise as well as the consolidated list, which they speak of malafide the intention and manipulation. Hence, it is also doubtful whether the screening committee has been constituted at all in the Kachar district. It is also observed that all the other districts have prepared and submitted a single constituted civic list in conformity with the guidelines issued by the then Director of Elementary Education, Assam. Whereas Kasar district had submitted multiple lists time of time without any signature of the other committee members, but only under the signature of the DEO, which was a clear violation of the guidelines issued by the Director of Elementary Education, Assam, for appointment of the post of grade 4. So, Malak, in respect of Kachar district, Malak, there are multiple lists, Malak. But in respect of other districts, there is a single list. First is school-wise list, then a consolidated list was prepared, that was sent to the director, Malak. Thereafter, appointment was issued, Malak. But in the district of Kachar, Malak, they have sent 3 or 4 times Malak, different lists, Malak. And the consolidated list was consists of only the signature of the DO. In fact, in school-wise list also, the signature of DO is only present, Malak, not the other member.
So that's the basic thing. Now,
Those documents, my lord, my lord, we have tried to file additional, we filed, my lord, annexing 2-3 selection, my lord, the page number 213. 213 and 215. And over these documents, they have not taken any instruction from the
yes, is 213 and all.
Yes.
Your document.
yes, we have,
Signed by the all the 3 members.
yes. These documents were never placed before the DES, my lord. And that was asked by this honorable court repeatedly from the DEO office, my lord. That is never placed. That is never produced before this honorable court also. Just asked my last option. That's why I filed this additional affidavit last time, my lord, explaining this, my lord. That it was asked, but it was not placed. And the DEO, my lord, the last occasion, this letter instruction, whatever submitted, my lord, as per only the information has come from the director office, not from the office of the DEO, my lord.
So these are this page 210 onward.
Yes, Lordship.
Not 210, 200
Only 2-3 is.
13, 14.
Yes, Lordship.
215 onward.
Yes, Lordship.
Not 215.
Yes.
200, sorry. 220. All these.
Yes.
These are all signed by, these are more than 3.
Yes. Some members.
These are all disputed questions of fact. How to decide? That is a problem. How to decide? If they are not producing the documents, what to do? Where is the advertisement? Where is the advertisement?
Advertisement, my lord, page 34, my lord. In this not advertisement, the guideline. This is the guideline circulated.
Page 36, man.
Employment notice, type 2.
Yes.
And the annexer 8A, page 76. And the annexer 8B, page 78. This is the, my lord, inquiry report and the public select list, my lord, issued by the director after the direction of this honorable court. Annexure 7B is the inquiry report. Page 73.
No, so it is on the basis of this High Court order
Yes,
that it has been selected.
yes,
These are the petitioner.
yes.
No, so then why are they not appointed?
That is the question, my lord. They have not.
Not by Mr. Katania.
Yes, Malata. Regarding that, Malat, in fact, I've just referred to page 128, Malat. Page 129, that, regarding that inquiry, the finding is there, Malat. Page 129, serial number 3, Malat. The Honorable High Court, by its order dated 12/7/2018 in WBC number so and so, observed that the recruitment to the grade 4 post in Kasar district could not have been dealt with in a more pragmatic way. In that view, the Honorable Court directed the DO Kachar to prepare a bona fide select list, consolidated list, on the basis of individual list from the respective school and in order of merit as against respective schools. But the said exercise was never undertaken by the DO Kachar. The DO neither examined, compared the school-wise list prepared earlier, nor even prepared a bona fide consolidated list. Instead, the DO has submitted the earlier list prepared in 2011 when he was called to appear before the inquiry committee constituted by the Director of Elementary Education, Assam. Thus, the direction contained in the judgment so and so dated of the honor never been carried out in letter and spirit. Though in 2018, DE Assam has constituted the inquiry committee and accordingly inquired into the matter to dispose the issue, but the committee prepared a list of 50 candidates on the basis of the list submitted by the DO, which were not signed by the other member of the screening committee. Hence, the list prepared by the inquiry committee constituted by the Director of Elementary Education, Assam, also could not be ascertained as a bona fide list, as no pragmatic exercise was ever undertaken neither by the DO nor by the Director in the process of preparing the list. So, the list prepared in the year 2018 is also the list given in the year 2011, madam. There is no exercise was carried out to ascertain whether those lists were bona fide or not, madam. So that is why in the subsequent inquiry, my lord, this finding was arrived at, madam.
Now 20 years have gone past.
Yes, madam.
Whereas, my lord, the director,
This petition was filed in 2024,
yes, Ashwin.
right?
Well, my lord, series of litigations are there, my lord. This is not the first litigation, my lord. Litigations after litigations, my lord. Since 2010, litigation
How many
started.
times? Third round?
Yes, in the page number 38 is the first litigation in the 2011.
Ah.
38.
Ah.
Thereafter, my lord, page number 40 annexure 3, it is another litigation in the 2010, and my lord, thereafter, in the year 2012, order was passed, a common order was passed, my lord, by this honorable court on 5/6/2014, page 47. Common order was passed. After that order, my lord, direction was given to give appointment to all the, in respect of all the districts. After that order, my lord, page annexure 5, page 61, there, and impugn order was there, issued by the director on 22nd December 2014, whereby the Kachar district has been excluded by the director on the ground that there are 3 lists from the DEO Kachar, therefore it is doubtful, so it is the kept aside. Thereafter, the impugn order was put to challenge, my lord, before this honorable court in the year 2016, and this honorable court, my lord, directed that whatever happened. So director will do a fresh inquiry, and after doing fresh inquiry and page my lord 69, verifying the records of the selections, and will publish a fresh list. That is the reason, my lord. That's why, my lord, director conducted the inquiry, and in the inquiry he called for all the teacher, headmasters, DEO and block officers in his office, and thereafter it was verified, and thereafter this list is published. And after that, this matter was placed before the state level selection board, and the state level selection board, my lord, had put their signature. 3 members were there. 3 members put their signature. Page 77.
2016, what happened?
2016, this honorable court directed the Director of Elementary Education, Assam, my lord, to fresh action, inquiry, and thereafter list should be published, and thereafter on the basis of that appointment should be given. And thereafter, my lord, the director has conducted the inquiry and the list is published. And inquiry,
This public when?
list published, my lord, it was,
Say,
page, my lord, it starts from page 73.
then what happened?
Then, my lord, there was no appointment, and there was only correspondence between the department director to
then-
secretary. We preferred a writ petition again in the year 2019 to the annexure 9, page 80, my lord. And this honorable court directed to take approval from the government and complete the process. Thereafter, we filed the contempt case. The contempt case was, my lord, going on, and their correspondence are going on. The director, the finance department, and education department correspondence are correspondence. Annexure 10A, 10B, 10C, 10D. These are the correspondence, my lord. And after that, they have
Now the present.
contempt is closed somehow, and the present writ petition is filed. After filing of this present writ petition, my lord, in order to escape all these activities, my lord, they have suo motu conducted an inquiry. This is the inquiry report what my learned friend has submitted after filing this writ petition, my lord. When this honorable court is taking up the matter, my lord, they have conducted parallel proceedings. That is also not permissible. And in order to just to avoid, my lord, they have
I think best to release from faster than this.
I leave it to Lord to whatever.
What to do?
I pray your lordship to allow this, my lord. But for these people are very poor people. They are running from pillar to post, and years after years they are doing the litigations, and their colleagues have been appointed throughout the state of
There's
Assam.
only no time now. So we'll do it next after September. Okay. We'll list the matter. Prepare the party list the matter on fourth. Third.